Good morning and welcome everybody to day 2 of hearing 13 of the Plymouth District Plan hearings. We had a good day yesterday. I'm looking forward to another good day today. We would like to open, well, I would like to open with a prayer, a karakia. And I think, Antoine, you're taking the mantle during this hearing, so you could just start us off, and that would be really appreciated.
Hey, kia ora, Stephen. O tira he mihi kawana kia koutou. Ko tai mai nei tēnei rā ki te whakawhiti ngā kōre pāna ki te huarahi mui a tātou. Nō he mihi kawana kia koutou. O tira he mihi kia rātou ngā tini aitua ka wainganui a koutou. Nō reira haere atura. Ai papaki kawana ngā tai ki tarai ngā ka pō, ka ao, ka watia, ka piki tuara, ka piki taka, ka piki ta marama kia koutou katoa. Ai te timatanga o tātou wāhanga. He tukuna atu ngā mihi ki tā tātou kaihanga nāna nei te timatanga, nāna nei te whakawoti ngā mea katoa. Nō reire he honore he korore ki te atua, he maunga ronga ki runga te whenua, he whakaro pai ki ngā tangata katoa. Hanga te atua he ngā kauhau, ki roto ki tēnā mātou. Whakatongi a tō wairua tapu, hei āwhina, hei tohu i a mātou. Ia ko hoku ngā mahi o tēnei rā, o tira mai te timatanga o tēnei rā ki te whakamotinga o ngā mahi. Whakatengu te atua te tama mai te wairua tapu, āmene.
Thank you very much, Antoine. This is a continuation from day 2, so I won't cover all of the aspects that I did yesterday. Although I will introduce the panel for those that weren't here yesterday. So my name is Stephen Daish. I'm the hearings panel chair. I'll let the 2 other commissioners introduce themselves, starting with you, Antoine.
Good morning, everybody. Antoine Coffin, Hearing Commissioner. 25 years in resource management, Hearing Commissioner for about 10 years or so. I was just about to say, good to meet you all, but I can't see you all. So I look forward to hearing from you soon.
David.
Yes, good morning, everybody. David McMahon, planning practitioner, Wellington-based, originally Christchurch, Hearing Commissioner since 2001, focusing on resource consents, designations, and policy and plans. In the last 2 years, I've been involved in 3 key heritage hearings, each with different outcomes, and as resource consent applications. So I'm very conscious of the importance of words in plans and the provisions in plans that help shape those decisions. So really looking forward to day 2 of these proceedings. Thank you, Stephen.
Thank you. And just for everyone, our Zoom protocol is that you'll see the room with the reporting officers and any submitters who attend in person. And I understand we might be seeing the iwi submitters here later today, just in person. If you're not participating, can you please turn both your cameras and your speakers off and just listen in. We will want to have those representing a party with your cameras on as we proceed on the way forward. So our first submitter will be Trustpower. So those representing Trustpower, if you could please turn your cameras on. And there's someone there, Anthony, is that? You've got your camera.
Morning, it's Romay Callan here representing Trustpower today.
Hello, Romay, how are you?
Good, thank you.
Yes, and sorry we didn't quite get to you yesterday. And really appreciate you being available this morning to take us through the Trustpower position. So thank you. The floor is yours.
That's all right, and no need to apologise. I know you've got an important job, and the submitters have taken a lot of time to turn up and have their turn in front of you. And I think the way that you treated some of them yesterday was very commendable, and quite happy to wait for my turn. And having said that, I don't propose to take up too much of your time today. You've heard from both myself and Ms. McFarlane Hill from Trustpower throughout some of the other hearings, and apologies from Ms. McFarlane Hill that she can't attend today. But yes, I know that you're aware that Trustpower's main thrust is to ensure not only the ongoing operation of their facilities in New Plymouth, but also the ability for them to potentially enhance the generation output where there's opportunities to do so. And that, of course, that approach is supported by the National Policy Statement for Renewable Electricity Generation. So in terms of the heritage chapter, only the Mangere hydroelectric power scheme is heritage listed, and the fact that it's listed is not in contention at all. And you would have heard Ms. McFarlane Hill give some history to that scheme in the past. So instead, what we've done is request a few minor amendments to the heritage provisions so that their activities and potential future enhancements aren't frustrated in any way. So I'm happy to answer any questions that you may have.
Yes, thank you, Rome, and yes, very clear statement of evidence, and thanks for the plan and everything that goes with that. Commissioner Coffin, could you please start with any questions you may have?
Yeah, thank you. That was going to be my introduction, that the evidence you've provided to us is actually very clear and concise, and it's very clear, not only one which you've mentioned, that you weren't questioning the listing or the scheduling, and those amendments you've set out quite clearly for us and helpful in terms of what relief you're seeking. So I didn't have any questions or clarifications.
Right, thank you.
Thank you. Over to you, David.
Okay, thank you. I do have a couple of questions, Ms. Romay. I'm working from your Appendix A of your evidence, pages 8 through to 10, and just looking at the principal changes that you're suggesting. One is to policy P3, which effectively is to add a qualifier to the end of clause 3 of that particular policy. Can you just take us through the need for that qualifier, please?
Our main thinking there is, so of course it says to avoid adverse effects where practicable, but then there should, in our belief, be the reference to the effects hierarchy. So where avoidance isn't practicable, that there should be then that requirement to remedy or mitigate adverse effects as well.
Yes. Do we find that hierarchy in other relevant policies in this chapter that you can point to? I'm perhaps not as familiar with the other policies, and that I've been focused on the ones that impact Trustpower's activities, but I'm sure your council officer would be able to answer that question. Yes. Where there's a similar policy for, this policy relates to heritage buildings and items, where there's a similar policy for archaeological sites or character areas, would you expect a similar qualifier?
Yeah, I would. And I think that there's a general understanding that we follow the effects hierarchy, but I don't think it hurts to lay that out.
Okay, thank you. My second and final question relates to the rule change that you suggested, and that's at the bottom of page 8 of Appendix A.
And so that's the adding in the controlled activity
Yes.
status. Yeah.
Yes. Now my question there is that rule would apply to all activities, not just utilities or infrastructure. Is that your intention?
Yes, so long as, and this rule's restricted to where there's an operational need
Yes.
to be located within the mapped extent. So you'd have to demonstrate that first. And I think that operational need is really focused on infrastructure and utilities.
Yes. I'm not sure whether you've had an opportunity to read the right of reply on, I think it's hearing 5 on environmental areas, SNAs, and I know that you and your colleague, Ms. McFarlane Hill, presented at that hearing. Did you have an opportunity to read the right of reply from the officers on that?
Yes, I have.
Yes.
You might need to refresh my memory.
Yes. One of the recommended changes in that right of reply related to an issue that I'd raised with the officers about the need for consistency of terms. You might recall that the policy, one of the policies provided reference to RSI, regionally significant infrastructure, and that term was not carried through into the subsequent rules. And in their right of reply, the officers have ditched RSI as a term, relied on infrastructure, and added the term renewable energy facilities, or an equivalent term to recognise the MPS on that, a very long-standing MPS, I might add. And I just wondered whether that approach might have some footing in respect to these historic heritage rules. It's a long introduction to asking that question, but I'm well, not concerned, but I observed that the new controlled activity would apply to all activities, not just renewable energy activities or infrastructure activities. And I wonder whether, in the absence of a case by other submitters, and I'm not saying there isn't a case, but if there was not a case for this sort of change, could it be ring-fenced to relate to renewable energy facilities or infrastructure generally where there's an operational need?
We'd be more than happy for that change and that consistency of approach across the plan.
Okay.
That was a nice quick answer to your long question.
No, that's fine. And I guess that it's something I'd like the officers to come back to us on their right of reply, perhaps verbally at the end of the hearing, but certainly in their written right of reply. But apart from that, Mr. Romay, that your statement was, as the other commissioner said, very clear. Thank you.
Thank you.
Yes, Romay. I just had one further question about the mapping of the extent in your Appendix 4. I don't have the original map here, but can you just describe, you're seeking a reduction in the area, is that?
Yes, so the original mapping goes right out to the road boundary. Yes. And then it goes basically to the end of that bush line at the base of the boundary. So it stops somewhere in that bush. So yeah, it has been pared back quite a bit, and part of the thinking, you'll see on that diagram in the top left-hand corner, there's lot 1 DP. Yes. That's the Powerco substation. Yes. So, and there's that little patch of grass on Trustpower's land next to it that at some time may be used for, may turn into an impervious, needed as an impervious surface, whether it's to extend the car park or whatever, but that's already part of the infrastructure area. So that was, you know, some of the thinking there was to exclude that paved area on that side. And then to the other side, you can see there's 2 ancillary buildings already on site.
Yes.
And Trustpower and some of their other facilities have had a situation where they've been refurbishing staff rooms and so on, and have encountered asbestos. So I've had to put and create an external prefab while those works were being undertaken, so that their staff aren't exposed to asbestos. So sort of thinking about those kind of situations and allowing for them to happen without necessarily needing to go through this consent process. And so it's an operational thinking rather than a heritage thinking.
Yes. I wonder whether there's any initial reaction from the staff team on that suggested change. Any thoughts?
My initial thinking was it is a little bit tight, particularly on the left-hand side, the extent, but it's something I'd like to get Michael involved in, and we can go and have a look at the site and do a site visit and have a decent look.
Yes. I love looking at power stations myself. It's something I've had a lot of involvement with. I think I've been to probably 90% of all the power stations in New Zealand. So they are fascinating historical sort of things in our landscape, and these older ones are really interesting. So yes, that would be great if you could have a look and take the time to do that. I think that would be good. So Roma, I think that's a good next step on that. And
Yeah.
just
If you do need to go onto the site rather than just observe it from the road, because of COVID, there are certain protocols that will need to be followed. So, and they're different from each site. So I don't know what those protocols are for this site, but yes, if you do need to go on, make sure you get in touch with us in advance so that we can make sure that that's all sorted for you.
all good. All right. Well, I think thank you for your evidence and your participation, and we may see you again. I'm not sure. There's plenty to go on our schedule. I'm not sure whether Trustpower's got other matters.
Yes. Well, if we don't cross paths again, thank you for your time and consideration for all of Trustpower's submissions.
Great. Thank you. Thank you, Rome.
Alrighty. Thank you.
Right, so we'll just move to our day 2 schedule. So the first submitter is Anthony Vincent. Are you there, Anthony? Yes.
Here we go. Yep, I'm here.
Well done.
Morning.
Welcome, Anthony.
Good morning.
Yes. So just we've got a statement from you, which we've read. So just take us through the key matters from your perspective, and we may have some questions.
Yes. Good morning, ladies and gentlemen, and thanks for the opportunity to present this submission. I'm going to read my submission out. My name's Anthony Vincent. I'm a trustee of one of the trusts that own the building here at 11 Gover Street, and I'm also a director of the accounting room, which is a tenant of this building. So just to give you a little background about me. So this is a verbal submission in regards to the removing of site 135, the Boom Brothers building, or 11 Gover Street, from Schedule 1. So just as a bit of background, we purchased the building back in 2003, and we did so to run our accounting business from this building. We'd outgrown our previous rented premises, and we looked for a while to buy a suitable building which had a reasonable profile and parking. And then we found the Boom Brothers building, and it was pretty much perfect for what we wanted. It was quite dated from the outside, and inside it was pretty run down and needed quite a significant tidy up. And we did that. We added interview rooms, gave it a renovation, moved the front door back to its original spot, jibbed and painted, and we gave it a complete makeover downstairs. At the time, we did check that the building wasn't a heritage building, and I guess that was one of the reasons why we bought it. 8 years later, we did the same to the upstairs. We modernised it, we built offices, and we added a boardroom. I think, well, we believe leaving the building on the district plan heritage buildings and item schedule, or Schedule 1, will hamper any future development we or future owners may want to do with this property. As an example, I can see there's an opportunity to build modern apartments, either residential and or commercial, for commercial business or residential living, or a combination of those, and that could be an opportunity in the future. We haven't got any plans at this stage to do that, but that's not to say we could have in the future, or a future owner may want to do that. So I've read the significance assessments guidelines issued by Heritage New Zealand for assessing historic places and historic area for the New Zealand Heritage List. And I just don't believe the case for maintaining 11 Gover Street as a Schedule 1 heritage building is strong enough. We don't believe our building meets enough of the criteria in Section 66(1) of the Heritage New Zealand Puhari Taonga Act 2014 to be added. To quote the guidelines, while a historic place or area only has to meet one of the criteria to be eligible for list entry, it will usually satisfy multiple criteria. So looking at the criteria, and I'm assuming that this is how it got onto Schedule 1 in the first place, that it had to meet one or more of this criteria. So looking at the criteria, aesthetic significance or value, I don't believe 11 Gover Street has particularly aesthetic qualities that are considered to be especially pleasing, particularly beautiful, or overwhelming to the senses, eliciting an emotional response. While we have tidied it up and painted it, the building isn't, in my opinion, particularly beautiful. Archaeological significance doesn't meet the criteria here, I believe. Architectural significance. So the building is 95 years old, and while there may be a limited number of buildings of this age in New Plymouth, the building was built to old building standards, which now don't comply with new building standards. And this will result in significant cost to make the building compliant with new building standards and seismic strengthening requirements. I acknowledge out of Section 66 criteria, this criteria may be the only applicable one, in my opinion. Cultural significance, I don't believe 11 Gover Street has strong cultural significance. Historical significance, other than being built and occupied by an early local building company, I don't see the historical significance. Scientific significance, I believe that doesn't apply. Social significance, so again, 11 Gover Street has been a workplace, and while many people have worked in the building over the last 95 years, I don't believe it has a strong social significance. Spiritual significance, I don't believe 11 Gover Street has spiritual significance. Technological significance, again, non-applicable, I believe. And traditional significance, I don't see how 11 Gover Street has a strong traditional significance. I'm not aware that it has been used by cultural groups over the years or reasons to suggest it has traditional significance. So Heritage New Zealand Puhari Taonga indicates there is evidence that this building has high heritage values. So I would like HNZPT to provide more information of this evidence. So as owners, we're struggling to understand how a privately owned building gets onto a heritage building schedule without consultation. What are the benefits of owning a building on the heritage building schedule? We can see many disadvantages. I'm told we'll have to seek approval before we do anything to the building. We have to carry all the costs of maintaining the building, and we receive no financial contribution to costs. We get to carry all the costs and told we can do, and told what we can do and how we have to do it, but we just don't see the fairness in this. So that pretty much completes my submission on that first point.
Thank you. So you've got another submission on a different building, is that right? Or
Yeah, no, same building,
Same
but it's an additional point to HHR7.
the rule? Okay.
They're all
Yeah,
you want me-
take us through that as well.
Right.
Ask questions to get it.
okay. So at the moment, HH7 involves alterations and additions to the exterior of a scheduled heritage building, and all scheduled interior elements identified in Schedule 2. And we want to add earthquake strengthening so that the rule does not apply to earthquake strengthening. So again, we bought the building, did much of the renovation work before the tragedy of the Christchurch earthquakes, and then the talk of the earthquake strengthening and the percentage of MBS started. Council contracted Becker to come in. The engineer wandered around without doing any apparent technical work and came back with a 19% MBS. We weren't happy with this rating, so we contracted Tees to re-inspect. 2 engineers came through, spent much of the day examining and testing, and the resulting report was an MBS of 39, a more satisfactory result, but still not ideal. But it did buy us time to actually get things sorted. Our building was built in 1926. Building standards were lower then, and the building to protect from large earthquakes was not a focus, I believe. And there may have not even been standards when mixing concrete back in 1926. So now landlords are expected to spend hundreds of thousands of dollars strengthening their buildings with little or no financial assistance. We've had a conceptual strengthening plan done by Miyamoto, and we've had that a QS prepare some costings based on that plan, and the estimated cost to strengthen is very significant based on that plan. We've since met with Red Jacket here in New Plymouth about redoing the strengthening plan, as we feel the first one was over the top. However, until we sort various issues with council and the heritage issue is resolved, it was better thought to put things on hold. So we can throw any amount of money at this building, but at the end of the day, it's still an old building built to old building standards. And as owners, we've breathed some new life into the building, but this has been purely cosmetic. There's still an underlying issue of trying to upgrade an old building to current building standards. The cost to seismic strengthen looks significant, and this cost will be increased further if strengthening is allowed only from the inside of the building. The south side of 11 Gover Street is rough. There is no attractive facade. Photos indicate it was once attached to another building. And the east side is relatively hidden and is not readily seen by the public. It sort of faces another building, and there's an alleyway there. These two sides could be strengthened from the outside if required without overly detracting the overall aesthetics of the building. We would request that an additional point be added to HH7, stating that this rule does not apply to earthquake strengthening. The north and west sides could possibly be strengthened from the outside, but there would be issues with the bracing protruding onto the public thoroughfare. A heritage architect may have some thoughts on how to strengthen these sides from the outside and maintain the aesthetic value of the building.
Thank you. Oh, I'll take my scaffold. Thank you, Anthony. Very clear statement. Thank you for reading us through that. We'll see whether Commissioner Coffin has any questions first.
Hey, thank you, Mr. Vincent, for your submission. I just wondered whether you'd sought any advice from a consultant or an expert in the heritage area, just to give you some advice on those values that have been identified in the Murray and Kelly report, or experts who've been relied on in the Heritage New Zealand submission, because what we receive is they bring along their experts and the provided assessments which we consider, and it's always hard for lay submitters when they turn up, and even though you might feel really strongly that these experts might not have got it accurate or agree with your position, but it's always good to be able to have your own advice. And I just wondered whether you'd been able to get any advice at all.
No, the comments made are of a personal opinion. The only expert we've probably contacted other than engineers is we have touched base with, I think his name's Ian Bowen, who's a heritage architect, I think out of Auckland, possibly Wellington.
Bowman, is that right?
Bowman, that's the man. Yeah.
Oh, yeah.
So he's indicated that if we were to proceed with the strengthening, he would be interested in assisting and giving some advice on the project. But that's really the only expert that we've touched base with.
Okay. And just in terms of the change to 7, I just said there was a list there of particular that would apply to. You were looking for an addition which would include, and these are my words, earthquake strengthening.
Yeah, that's correct. There's other external additions and alterations on that list, and we wanted earthquake strengthening added to that.
Okay. Thank you.
Commissioner McMahon? Turn your speaker on, David.
Good morning, Mr. Vincent. Can you hear me okay?
Yes, I can, loud and clear.
Good. Just having a few problems with my mouse. Yeah. Just starting with the last point first, the addition to Rule 7. That rule at the moment is a restricted discretionary activity. So that means a resource consent is required, and the matters that the council can consider are limited by a list and the plan. But you're seeking by the addition to actually have that activity, earthquake strengthening, as a permitted activity, not requiring a resource consent. Is that what your point is?
We understand that at the moment, like you can add fire alarm panels and security alarms, security lighting and sprinkler inlets, but there's no mention.
Without the need for consent. So they are exemptions from that rule. So they would be permitted activities unless they're captured by another rule.
Yes.
So if we were to add earthquake strengthening to that list, that would also be exempt from that rule and possibly exempt from the need for a resource consent. I'm just wondering whether that was your intention.
No, I guess we just wanted to be able to add earthquake strengthening to the list so that was at least allowed or to be considered. We understood that because it wasn't on that list, then we couldn't earthquake strengthen from the outside.
Okay, I may have misunderstood the rule, but that's not my reading of the rule at all. Well, maybe the officers can clarify on that in their right of reply. But you're not. Are you happy to lodge a resource consent for strengthening?
Yes, we are. Yep.
Yes.
Yep.
Okay.
I mean, we as a normal building. Yeah, as a normal building, not as a heritage building. Yeah.
Okay. All right.
Because as a heritage building, I think we're going to be very limited to how that strengthening is going to be allowed.
Well, you do have some policy support for strengthening of heritage buildings in the provisions that begin with the P number.
Mm-hmm.
So that means that when your consent is lodged, one of the criteria that the council will look at is whether this sort of activity is anticipated by the plan, and clearly it is. I mean, the plan wants to. Sorry, I'm just got a noisy. Sorry, I'm not sure if that's coming through, but it's distracting me.
Okay. No, it's not. We can't hear it.
Okay. There is some policy provision in the plan that specifically recognises that it's one thing to list heritage buildings, but it's another thing to allow for them to be upgraded and strengthened over time. So if you're not aware of that, I'm just pointing that out to you, that there is policy provision that would be considered at the time that you lodge a resource consent.
Right. Okay. I guess just in reply to that, I guess our concern is that the bureaucracy we have to go through with a heritage building, and in our opinion, seems to be double layered. We not only do we have to apply for resource consent with the council, but then we also have to have it approved because of the heritage significance of the building.
Sure.
And that just adds layers. Whereas if it was just an ordinary building, I think it would be easier to do the work,
Right.
and probably at lower cost.
Yes. Is the building actually on the council's earthquake prone list?
We're on Schedule C, or we're listed C. So we were D, but when we had it reassessed to 39%, we went to C. So prone, yeah. So we had it upgraded anyway. So
yes. Have you received any notice from the council in terms of the need to upgrade the building?
No, only the general advice is that we have, I understand, 15 years to strengthen it. We're okay at the moment,
Okay,
but we have
yes.
that period of time too.
Yes, that answers my question. Okay.
Yeah.
Just moving back to the listing itself, Mr. Vincent, and you referenced the Heritage New Zealand criteria for inclusion on their list. That's just one part of the package, I guess, that the council have looked at when they consider listing. They've also looked at their own criteria, and I think Mr. Kelly and Mr. Murray took us through those in their report. And I think there's five criteria for a listing in their report. Are you familiar with those at all?
No.
Okay.
Yeah.
That's okay. I'm not going to ask you any detailed questions on them. I just wanted to point out that it's not just the existence of a Heritage New Zealand listing that generates the need or the desire by the council to list it. They've undertaken their own assessments of each building that's on the list.
Okay. Just to, like, the main question I guess we had was, other than I think we met with Lauren maybe two and a half years ago, and then we had a subsequent meeting up at the council, but we never really sort of understood how a building could just get onto a list without, well, no consultation, basically. I would have thought an owner of a building, there should be some consultation. There should be the ability to actually negotiate before it even gets onto a list. Now it's on a list. It seems we're sort of, it's on us now to try to get it off the list.
Sure. So is your total relief related in the sense that your primary relief is that you prefer the building not to be listed?
Yes,
but if it is, you'd like a change to Rule 7 to recognise earthquake strengthening of the building.
Yeah, our primary, the first submission is we want to get it off that schedule.
Yes.
We just don't see that, other than the there might be some pride in owning a heritage building, but everyone keeps telling me that if you own a heritage building, you lose control. You've got to answer to people. You can't do certain things with the building without getting approval. And that was never our intention when we bought this building. At the end of the day, it was a building to run our business from. And one day it was going to provide a bit of a retirement fund. We'd probably get some rent off it, maybe sell it at some point, but never did we envisage it was going to be a heritage building. And I know we're not the only ones in the situation. I know there's another 120 buildings around Plymouth that's probably faced with this, and I don't know what the owners are doing about it, but we just feel that it's it will hamstring any future development of this site.
Okay, no, I understand that. If it's probably no consolation to you, but the resource consent activity status for additions and alterations is a lower level consent than for partial removal or demolition, or partial demolition or removal of a building. So, which is a non-complying activity. Now, I don't expect you to understand those terms, but in general, restricted discretionary activities are usually approved with conditions. Whereas non-complying activities, it's a much more difficult prospect to get approval. So I'll just leave you with that thought in terms of the rule structure.
Appreciate that. Okay.
Thank you, David. I have just a couple of questions. One out of interest, really. The name Boone, is that the same family that Boone Architects are associated with, or is there any connection to South Office?
I think there is some relationship there. So Terry Boone was the founding member of Boone Architects many years ago. I think there is some relationship between Terry and the folk that started this building business.
Yes, it's interesting. These old firms and these old names.
Yes.
Part of the history, I suppose. So I just wanted to establish some facts, just so I'm really clear. In the operative district plan, your building was not listed on a heritage schedule. Is that right? In the previous.
In the past, I understood so, because we bought it many years ago, 2003, and we did our research, and there was nothing to indicate there that it was on a schedule.
Yes. Okay, so fact number 2, it is on the Heritage New Zealand list, because you quote Heritage New Zealand indicate there is evidence that this building has high heritage values. Where is that from? Have they given evidence on that, or you've seen the schedule of the listing that made?
So verbally, what we've been told is someone from Heritage New Zealand, I think from Wellington, came up here, drove around the CBD, and identified a number of buildings that had heritage significance. He particularly liked the design of the building. He liked the little ornate decorations on this building. And from my understanding, that's how it's got onto the Schedule 1. But that's about all I know. And as I say, I think there's about 130 buildings in the New Plymouth CBD that's been identified that could have heritage significance. So I understand that's how it's got onto the schedule. And I haven't looked at Schedule 1, but I understand there's a Schedule 1 of buildings with heritage significance.
Right. I've just had some eye contact with Ms. O'Byrne, who's our reporting officer, Brian, could you just take us through the facts of this building?
Yeah, sure. So I just wanted to clarify that it's possible to have a listing on the Heritage New Zealand list and on the district plan. So a listing on the Heritage New Zealand list, that's an information and advocacy tool only. There's no regulation associated with that. And then if you've got a listing in the district plan, that's where the regulation comes in. So there's no Heritage New Zealand listing for this building. I think where the confusion has come in is that Heritage New Zealand has supported council's recommendation to make this a heritage building in the district plan. So the criteria that Mr. Vincent was referring to before was the Heritage New Zealand criteria, not the criteria that council's used.
Sure, yes.
So this was a building that Michael Kelly and Russell Murray assessed when we were looking at the buildings in the CBD. So this occurred prior to notifying the proposed district plan. So we wrote to these owners as part of the draft district plan that was notified. So there was an opportunity there for them to speak to us, but we didn't hear from them. So we proceeded to include it in the proposed district plan. So the actual assessment for this building can be found in Appendix 1 of my Section 32 report.
Right.
So that's the actual assessment that you're referring to.
Yes. So Anthony, you mentioned that you had met with people at the council. I think you made a statement that you hadn't heard about this prior to the plan being notified, but did you receive a letter from the council about its inclusion or possible inclusion in the district plan when it was notified?
We've received a heritage building report. I'm just trying to see what date that is. Appears to be undated, but there's a heritage building report. Look, to be honest, had we received notification, I think that's what probably prompted the meeting with Lauren. I remember it wasn't in the council buildings, it was up in the library. And we met with Lauren O'Byrne originally. And then that followed up maybe a year later with a meeting up at the council, and we met with about 8 or 10 people. So I don't believe we did nothing about it. I think certainly if we did get the letter, that's probably what prompted the request for a meeting with Lauren. Yeah.
Yes. Well, we can get that all checked back on the council records, but
yeah.
The point is the council team here are telling us that they're very conscious that things don't go on these schedules without having some notifications and liaisons and discussion with the building owners. So I think we've established that there has been some form of notice prior to the notification, that there has been some discussion. So this just hasn't come totally out of the blue, has it?
No. So we would have got notification, and that's what prompted the meeting to discuss it. Yeah.
Right. All right. No, that's fine. I just wanted to be clear on the process. I happen to be, I suppose, lucky enough to be in Taranaki this week, where others have to zoom in. It's just part of my chairing role that it's easier for me to be here. So I'll just out of my own interest, I'll have a drive by and have a look. I'm not an expert. I'm a decision maker. I rely on experts to inform our decisions, but also just to clarify the position and the information that you raise as the owner is really important as well in the context of our decision making. So I'd like to thank you for the time you've taken. You've set your position out very clearly. I know it's a personal position, but you're obviously interested in the building and its past, and you do have a stake in this. So really appreciate your contribution.
If you're driving past, you're welcome to pop in and visit, have a look. Either myself or Diane O'Donnell will be here, and if you wanted to have a look around, you're welcome to.
Yes. Well, I'll probably just look at it from the street. Yep. So I think that's the key thing. But that's very helpful, and thank you so much again for taking your time to participate. And we'll hear back from the council staff on any changes or any thoughts they have when they give us their right of reply, which is just the final process before we make a decision.
Okay. Well, thank you. Yeah, and thanks for the opportunity to present the submission. Appreciate it.
Thank you. Thank you very much.
Thanks, guys. Cheers.
All right. So, Greymouth Petroleum, Karen and Jennifer.
Good morning, Commissioner Dash.
Morning, Ms. Bryce. How are you?
I'm very good, thank you. I'm actually not going to be presenting any legal submissions today. We think the focus of Greymouth's submission will be well covered by Ms. Carville's statement. So she will be available to answer questions very shortly, but we did file an updated appendix to her statement of evidence yesterday afternoon. So Ms. Carville, I'll just ask you to address the panel and take them through the several changes that were made to that appendix.
Thank you very much, Karen. Welcome, Jennifer.
Good morning.
Good to see you back again. So, yes, can you just take us through the amendments to Appendix 1, and thanks for filing that.
Yep, no problem. Apologies, there were just a couple of little errors. It was all correct in the body of my evidence, but in the appendix there were just a couple of items. So it was page 23 of my statement. And it's in relation to new rules proposed in my evidence, Rule 15A and 15B, in the description of the requirements for a restricted discretionary activity. So the first change was that I originally had where item 1 and then a matter in relation to building height, and then I had an item 2, and we had I had deleted item 2 in the body of my evidence, but neglected to carry that deletion through into my appendix during the drafting process. Item 2 on page 23, the building or structure is a temporary crane or derrick.
Yes, so that's come out. Yes,
Deleted, yep. And then the second one was just below that in item 1, under matters over which discretion is restricted. The second part of item 1 is deleted. So it should read the particular archaeological values associated with the site and the extent to which these values may be affected, full stop. And the remainder of that sentence is deleted.
Thank you very much for that. We've got those changes noted.
It was a fairly hectic time before Christmas when we were finalising this. Unfortunately, Ms. Hare, who's on the call today as well, was just checking through my evidence yesterday and picked it up for me. So
it's always cut and paste. It's quite it happens often. So it's really good to that you've caught it. Otherwise, we might have been scratching our head. So appreciate that.
Yep. So I just was going to take you through my executive summary in the same way that I've done.
Please,
before.
yes.
So,
yep.
Just starting at paragraph 14, which is on page 3 of my statement. Greymouth undertakes, as you know, various oil and gas activities in the district. Some of these sites are located in proximity to scheduled archaeological sites. And in particular, there are a number of scheduled archaeological sites located within Greymouth's Turangi and Kowhai permits, where existing established oil and gas activities are present. Accordingly, there's an interest from Greymouth in the chapter, and Greymouth made further submissions, which are generally in support of the historic heritage provisions. And there's a few amendments suggested in my evidence, which I'll just take you through. Now, so the first one is definition of the scheduled archaeological site. Overall, I support the inclusion of the recommended definition, as it provides clarity and certainty for the implementation of the rules in the historic heritage chapter. I also support the inclusion of clause B2 of the definition, which enables the extent of an unmapped archaeological site to be confirmed by a qualified archaeologist. In my view, this appropriately addresses concerns regarding the arbitrary nature of the 200-metre radius extent for unmapped archaeological sites, which is specified in clause B1. While the 200-metre radius is likely to be overly conservative for many sites, I do understand that it is necessarily arbitrary and conservative due to a lack of information. And recommended clause B2 provides an opportunity to reduce this conservatism on a case-by-case basis. In relation to situations where the extent of an unmapped archaeological site has been confirmed by a qualified archaeologist, I note that no setback from this extent is required in the rules, while a 50-metre setback is required from the extent of mapped archaeological sites. I assume that this requirement is due to some uncertainty with the mapped extents, and on this basis I consider that it would be appropriate and consistent with the approach taken for unmapped sites to enable confirmation of the extent of mapped archaeological sites by a qualified archaeologist and the associated removal of the 50-metre setback requirement. I also support the inclusion of clause C in the definition, which relates to archaeological sites with silent file status. I note that clause C states that these sites are accurate to the land parcel mapped, and therefore I've suggested a clarification to the wording of clause C2 just to confirm that. The next point that I cover in my evidence relates to maintenance and repair and upgrading of network utility structures.
And Stephen, I just wondered through you, I wonder whether we could go to questions at the end of each section,
Yes.
just
Yeah,
so
that
they're
was,
not lost.
yeah, that was going through my mind too. So Jennifer, I think we'll take questions as you go
Yep,
with
no problem.
each topic. Do you want to kick off, David, on this one?
Mind. I think I understand what you're saying in paragraph 18, Ms. Carville. Is there any action required to reflect your assumption there?
Yes, so what I've recommended in Appendix 1 is that there's an addition to A in the definition.
Hang on. Yep.
This is on page 24 of my statement.
Yes.
In the red text, I've suggested adding in where the extent of the mapped archaeological site has been confirmed by a qualified archaeologist and made known in writing to the council, the mapped extent is within that extent. And then a note at the end of the definition.
Okay.
So it's on the last page. And there might be other ways of achieving the same outcome, but this was the way that I could see it without making too many changes. A note in the definition that states the extent of a mapped archaeological site where it's been confirmed by an archaeologist.
Yes.
That rules in the chapter that refer to within 50 metres shall be read as within the extent of. So that would just line it up with the way
Yes.
that unmapped sites are dealt with.
Yes, so there'd be consistency between A and B in the definition.
Yeah,
By the inclusion of clause 2 and A to match clause 2 and B.
that's right.
Yes, okay, I see that. So I guess this will be a live process, really. So how will that work? I mean, if there's work being undertaken and there's some confirmation of by an archaeologist that the extent is perhaps, say, less than a 200-metre radius, which is mapped. How does that flow through in terms of the activity status?
Yeah, so I guess in terms of the activity status, if the location of the activity is sitting, therefore, outside of that extent,
yes,
the rules would apply as if there were no archaeological site rules.
okay.
So whatever other rules in the plan apply.
Yes. Conversely, if the extent is greater than the 200, then
yeah, and I guess I had read the rules certainly in terms of the unmapped extent. So in B, and
yes.
this would also apply in A, that it couldn't be expanded to be greater than 200 metres through that process. So
Okay.
on the assumption that 200 metres is conservative and that the existing mapped extent is conservative, that when a qualified archaeologist came in and reviewed it and confirmed it, that it would by its nature be refined rather than expanded.
Yes. Do you think what you've just said is captured by the existing 2 and B and the repetition of that in A as you've requested? That that the 200 is the maximum?
I think so. Let me just read it.
Because the word "or" appears both in between 1 and 2.
Mm-hmm. That's a good question.
I understand the intent. I'm just wondering about the delivery.
Yes, and this was something that I looked at in C, and possibly also in my hearing 14 evidence. So in C, we've got wording within the mapped land parcel to confirm that it's within that extent that would be known in the plan. I do wonder if it might be worth clarifying that
Yes.
that it can't expand that area.
Okay. Well, there's two things there. Your intention, I guess, and what the council's intention was. It wasn't something I actually asked the council when they reported yesterday. And then secondly, the delivery to reflect whatever the intention is.
Yeah.
Okay. So sorry to interrupt on that, but
No,
it's just something that struck me.
Yep.
Antoine, did you have any questions on this topic?
David's picked up on my points. It was just around understanding what was intended and then just making sure that those amendments that you've suggested to us actually deliver it. Because I was thinking perhaps from a slightly different view was making sure it's really clear the difference between the scheduled archaeological site and its mapped extent versus where it hasn't been mapped, but you're actually going through a process during the delivery of a project. Archaeologist has gone out there, mapped an extent and said, yes, this is what I think it is, and then provided that to council in writing, and then that's the provision which picks that up. So as opposed to there's a mapped extent in the plan, but an archaeologist goes out and says, well, the OR then applies. I know that it says that's the extent, but this is what I think it is. And so you end up a contest between the mapped extent that's in the scheduled site versus an archaeologist, which may happen as a matter of course in terms of the refinement of doing the project on the ground. But the way this which is giving you an either or, it's giving you two pathways. So I was just clarifying. I think that was where David was heading towards as well.
Yes, and if I could just add to that, and it's just some context for next week's hearing. We heard yesterday that the likelihood of the extent of SASM identified sites could be greater than the mapped extent because of the greater range of values represented under by the SASM. So the possibility of the mapped extent of SASMs extending beyond a mapped radius could be greater than, dare I say, at a traditional archaeological site.
Yep. Yeah. Okay. So, and
my view is certainly it's a prudent thing to do if a place isn't mapped, to send out the experts to be able to identify where that extent may be. That seems like a prudent course of action. I suppose what we're looking here is if that was something that we're agreeable to, what's the pathway for that to occur where it's not getting confused with other pathways.
Yep. Yeah. And I guess the point that I had picked up on, which I felt was inconsistent in the plan, was that a 50-metre setback applied from a mapped extent.
Yes, that's right.
Yes.
But no such setback applied to an unmapped extent once it had been confirmed. So that was really what I was trying to.
I think you picked that accurately.
Yeah.
Jennifer, one of the questions from me is what would you see being the mechanics of this? Like the mapped extent would still be in the plan. That would be that couldn't be expunged, could it, by a notice to the council in writing? Would that just come about as part of processing a resource consent that the rule triggered, and then that would just be information for determining conditions or the need to have the resource consent?
Yeah, that would be what I would envisage. I agree. It wouldn't change the district plan, but it may be used either during a resource consent process if there were other triggers to confirm that where the archaeological site trigger applied or that it didn't apply, or through a process for an application for a certificate of compliance, or even just an exchange in writing with council to confirm that consent were required, for example.
I'm just thinking aloud that a lot of the rules do hang off. There's been some more work done around relating rules to actually mapped extents and those sorts of things. Just the wording of the rules themselves do rely on the geographic mapping of places in the plan. So whether you had an archaeologist thinking hypothetically that might come and say, look, the mapped extent is smaller than what's shown on the district plan, the rule's still triggered by the map consent. Mapped extent, sorry. So I'm just trying to think about the practicalities of this for the consenting team.
Yeah, I guess the way I was, oh, sorry for interrupting.
Yeah, no, you carry on.
The way I was reading the definition was that it defined mapped extent, so that it took something that was on district plan layer and put words around it to define how it applied. So in the example of an unmapped extent, it was a 200-metre radius, which, while that might not be drawn on the plan, is the equivalent of, you could have a circle drawn on the plan, for example. So that was the way in which I was reading it. If you could change that 200 metres, that 200-metre circle, with part B of the definition, then a similar approach could be taken for A. There may be another solution as well, looking at the 50-metre setback. If there's certainty that the mapped extents are appropriate, then perhaps that's another way of tackling it.
But the mapped extents, they aren't just a general radius of whatever around a point on a plan, are they? They're all different shapes and it's based on archaeological information. So the mapped extents, to me, I think, and I will check with the staff when they do a reply, are intended to be based on reasonable information. Where there's not that information, they become unmapped and B applies. So don't you think there is a distinction that a mapped extent is based on evidence?
Yes, but I presume, and this is where I acknowledge that council officers will be able to advise you better than I, but that the 50-metre setback was some kind of recognition that there was uncertainty.
Okay, no, just certainly something that the staff will turn their mind to. Just understand your position, so that's good. Let's move to your next point.
At page 4, paragraph 20. So this is looking at recommended rules R14 and R15, which relate to the maintenance and repair of network utility structures, and also recommended rules R16 and R17, which relate to upgrading. So these rules are recommended in the Heritage Section 42A report to replace notified rule R13, which covered both maintenance and repair and upgrading. While I concur with the reporting officer regarding provision for maintenance and repair of network utility structures as a permitted activity where there is no land disturbance and no change to the footprint of the structure, I consider that a non-binary consenting pathway should be provided for both maintenance and repair and upgrading of network utility structures, and that this pathway should include permitted, controlled and restricted discretionary activities dependent particularly on the extent of land disturbance. In simple terms, my analysis concludes that permitted activity status, in my view, is appropriate where there is no land disturbance other than those small items that are permitted, and no change to the footprint of the structure, and provision of notice to specified parties has been made at least 10 working days prior to new earthworks commencing. That controlled activity status, in my view, is appropriate for maintenance and repair activities where earthwork limits are met, and for upgrading activities where earthworks limits are met and there is no change to the footprint of the structure. In both cases, controlled activity status should also be contingent on provision of notice to specified parties. And in my view, restricted discretionary activity status is appropriate for maintenance and repair and upgrading activities not meeting the relevant permitted and or controlled activity requirements. On this basis, recommended rules R16 and R17, in my view, should be deleted, and recommended rules R14 and R15 should be amended to provide appropriate consenting pathways for maintenance and repair and upgrading of existing network utilities. My conclusions are based on the points set out in paragraph 23. Maintenance and repair and upgrading in relation to network utilities are both defined in the proposed plan. The definitions are narrow, relating only to those works that are necessary to continue the operation or functioning of those network utilities, and those works that increase carrying capacity, efficiency, security, or safety, where structures are of the same or similar location, scale, and character. The ongoing safe and efficient operation of existing network utilities is of critical importance, and works that meet the definition of maintenance and repair are required to be undertaken. Provision for maintenance and repair and upgrading enable efficient use and development of regionally, if not nationally, significant infrastructure. The least restrictive activity status needed to manage potential effects should be applied. In this case, where there is no land disturbance and the footprint remains unchanged, permitted activity status is appropriate, in my view. Further limits can be placed on volume, area, and location of earthworks so that maintenance and repair and upgrading activities undertaken as a controlled activity involve only a limited extent of earthworks and only in locations where earthworks have previously been undertaken. Control can be reserved over methods for undertaking and managing the effects of the earthworks and any advice received from Heritage New Zealand and Tangata Whenua to manage the effects of the earthworks. In Appendix 1, I have included a suggested controlled activity rule to be added to recommended rules R14 and R15, utilising the words from notified rule R13, which includes maximums for the area, volume, and depth of earthworks for maintenance and repair and upgrading of above ground and underground structures, and a requirement that earthworks are limited to an area that has previously been disturbed by the existing network utility since August 2005. This controlled activity wording for maintenance and repair or upgrading was also included in the sites and areas of significance Te Māori chapter of the proposed plan and was addressed in more detail in the section 42A report related to that chapter. The sites of significance report includes discussion of a number of concerns related to controlled activity status. I've addressed these in my evidence and conclude that controlled activity status is appropriate. Demonstrating compliance with the controlled activity requirements, such as the limitation to areas previously disturbed, will be incumbent on the applicant, and if compliance cannot be demonstrated, then restricted discretionary activity status will apply. Further, the matters of control enable effects to be managed through conditions of consent, including monitoring by Tangata Whenua and archaeologists as appropriate. I'm going to pause there for questions.
Sure. Antoine, do you have any questions on this topic?
Yeah, I just wanted to clarify your view on what you've proposed in terms of where tangata whenua involvement might be, because as you've set out, and I may have this wrong, and I'm happy for you just to correct me, where tangata whenua would be involved in terms of the monitoring role after consent has been sought. And as I've currently read the rules as they currently are, there would be an opportunity for tangata whenua to be involved and have input before an application is made. Have I got that right?
Sorry, before an application is made?
Yes.
there's some very similar rules and suggestions in my evidence for hearing 14. At the moment, the way I've worded it is for the archaeological sites, the focus has been on Heritage New Zealand.
Yes.
And in my hearing 14 evidence, I've currently suggested drafting that includes Heritage New Zealand and Tangata Whenua, but obviously open to further thoughts on that. But the wording for the permitted activity rule is that it includes provision of notice to Heritage New Zealand, and then the matters over if controlled activity consent were required, that matters over which control is reserved includes any advice received from Heritage New Zealand.
Okay.
Does that answer your question?
Yeah, it does. I just wanted to clarify that was what the intention was. Because I suppose there's the concern that it doesn't provide tangata whenua with the opportunity to have input. It looks like it provides for the monitoring of the earthworks if there were any, but having input into the site, and predominantly those archaeological sites are associated with party settlement. So it's like the others are managing it on their behalf, and that they're at the fence watching all the experts go about doing their assessments and things. And if I was certainly in their shoes, I'd be quite perturbed that everybody's has got good intentions, but they're sitting on the side watching it all occur. So
yeah, and my understanding, I obviously don't know the full breadth of detail about the all of the sites of significance in the archaeological sites in the district, but my understanding is that a lot of them do have both the archaeological site and the site of significance overlay
yes,
applied.
Yeah, we've certainly heard that from the officers. There's a lot of overlap, and they're just trying to work through a process which can make that quite both transparent, but also provide some certainty that you can deal with all of those values at the same time, because they're not separate sites necessarily.
Yeah, and so I definitely hear where you're coming from, that we've potentially got this sort of slightly artificial split in the rules, and yeah, certainly wouldn't be averse to consideration of taking that further into account in the rules if it was worded appropriately to take account of that.
Okay, thank you.
David, over to you.
Yes, thank you, Stephen. Ms. Carville, it's quite a complex set of rules here, because I guess we're dealing with some new recommended rules in R14 and R15 that have come out of the officer's recommendation and replaced previous rules, and you listed what those rules were, and then you're seeking to modify those rules. So I'm just trying to get my head around the sea of blue and red that appears in your appendix. But essentially, the plan did make provision previously for maintenance and repair and upgrading, but for some reason R14 and R15 didn't include the word upgrading. That's your first point, isn't it?
Yes. Yeah.
Okay. What do you make of that? Do you think that was intentional or an oversight? Or I think was it R13 previously used the word repair.
Yeah, so R13 is notified. Is notified related to maintenance and repair or upgrading.
Yes. Sorry, upgrading. Sorry. Yes.
Yep. And then the proposed, recommended rules from the Section 42A report split out maintenance and repair and upgrading, and proposed to provide for maintenance and repair in R14 and R15, and provide for upgrading in R16 and R17.
Okay. You haven't. So the changes that you recommended, the controlled, restricted, discretionary flow, does that require any further change to R16 and R17?
So
Consequential change?
my evidence suggests that I think that 16 and 17 should be deleted.
Yes, okay.
And amendments made to R15 and R16.
Yes,
Sorry,
okay.
14 and R15.
Yes, okay. What was the what was the default status where compliance with the permitted activity standards could not be achieved in the notified version?
In the notified version, it was a controlled activity that then defaulted to discretionary activity.
Okay. And so with the changes to R14 and 15, you're suggesting permitted to controlled, and then
restricted discretionary.
yes. And then later on, where you can't, where compliance with controlled activities is not achieved, restricted discretionary. That's the flow.
Yep.
Yep. Okay. And then on to fully discretionary on your page 23.
Can I just clarify there? If we lose 16 and R17, the cascade to restricted discretionary, that goes, doesn't it?
So what I've suggested is that there's some activity provided for as a permitted activity,
Yes.
Maintenance and repair or upgrading, where there's no land disturbance.
Yes. Okay.
Where
Yes.
there's very minimal disturbance. So those volumes and limits that were included in the notified rules, where those are met, that it could be a controlled activity. But if those are exceeded, then it would fall to restricted discretionary.
Okay. So you'd like to replace 16 and 17 with as restricted discretionary activities, with 15A and 15B as you've chosen them.
So 15A and 15B relate to new
okay.
network utility structures.
Right.
So the 14 and 15 the existing facilities, so dealing with any maintenance, repair and upgrading. So
Okay.
I guess in summary, my view is that where there's an existing network utility provision, it's appropriate for provision to be made for maintenance and repair and upgrading of those existing facilities as either permitted, controlled or restricted discretionary, largely dependent on the extent of land disturbance.
Yes.
For new facilities, that's the next topic.
Yes.
I've interrupted. Sorry, David.
It's okay.
No, that's okay. That was helpful. I can see the distinction now with where HH 15A and 15B come into play for new network activities. The only other question I had was, can you just remind me where the metrics in your controlled activity come from? Do they have some origin in the notified version?
Yep, sure. So R13 was the notified rule.
Yes, okay. And you've just simply carried the 0.3 and the 450 mils, etc., in the 10 square meters and the 5 square meters
Yes,
through into your controlled activity rule.
that's correct.
Okay. So we're really just talking about a difference in activity status and clarification that it includes upgrading of an existing utility for the controlled activity.
Yes.
Yes.
Yeah. Over what was recommended in the section 42A.
Yes. Does I note that there's a definition of maintenance and repair, and that
Yes.
specifically excludes upgrade. Is there a need for a definition of upgrade? I know, separate to the definition of heritage upgrade, But is there a need, was this an issue that came through in some of the preceding hearings?
Yeah, it was discussed in the Network Utilities
Yes.
hearing, and there is currently a definition that relates to upgrade of network utilities, and the wording in the Section 42A report was recommended to be amended slightly.
Yes.
Um,
Can you recall whether that changed at all in the right of reply when, in relation to those environmental chapters?
I actually was thinking about that last night and meant to check, but I haven't
Yes.
checked it this morning.
Okay. I mean, I guess what you're seeing and what other people in the audience are seeing is that just this desire from me for consistency across all the chapters. I think the right of reply on the environmental chapters was the first chance that Ra and Denise had to actually consider those issues about infrastructure, network utilities, and whether the word RSI was carried through, and seems that it wasn't seemed to be carried through, but it was changed. So yeah, I'm just sort of familiarizing myself again with those issues and seeing how they apply here. You've relied on the term network utility here. In light of the right of reply, I think that's still the current term that's being used.
As far as I'm aware.
Yes. Okay. Just check. No, that's all on 14 and 15 from me.
Thank you. Let's proceed to the next and final point. Thanks, Jennifer.
Commissioner. Okay, so this is page 6 at paragraph 27. So this is the point relating to new network utility structures. So I've recommended new rules 15A and 15B, I've called them, in my evidence to provide for new network utility structures as a restricted discretionary activity. The archaeological site rules recommended in the Section 42A report can be separated into 2 categories, those relating specifically to network utility structures, the maintenance and repair and upgrading ones we've just been discussing, and those relating to general land disturbance, earthworks and structures. The effect of this recommendation is that maintenance and repair and upgrading of existing network utility structures would be addressed by specific rules, while new network utility structures would be dealt with by the general rules. It's my view that it will be appropriate to include specific rules for new network utility structures. Specific rules would provide consistency with the approach taken for existing network utility structures and would provide clarity regarding the applicable provisions for new network utility structures. In my opinion, specific rules for new network utility structures and application of a similar matter of discretion to that recommended in recommended rule 10, but combined with some additional matters tailored to network utilities, would provide a clear consenting pathway for network utilities, giving effect to the RPS and proposed plan objectives and policies framework, while ensuring that appropriate consideration is given to practical alternative locations. That was the end of what I was going to cover. So any questions on that last topic?
Thank you. So we'll go through the same order. Commissioner Coffin.
Just to clarify, those are those matters that we just you were discussing with David in terms of R15A and R15B. That's correct.
Yes.
Yeah, that was most helpful to me. I didn't have any further questions.
Okay, great.
David.
Just one from me, Ms. Carville. The matters of discretion that are in blue on page 22.
Yes.
Which is the officer's revised recommendation in the 42A.
Yep.
Do they apply to 15A or 15B, or what are you saying in your paragraph 30 that there needs to be matters carried over from rule R10 in addition to those?
So the Let me just check R10. I'm not sure.
You said that specific rules for an application of similar matters of discretion to that in recommended rule R10, but
R10.
combined with additional matters would provide a clear consenting pathway. And I just wasn't sure how that related to the matters of which discretion is restricted at the bottom of 22, because just with the way the page breaks have worked, it didn't appear to me that those matters of discretion applied to 15A and 15B as proposed by you.
Yes, and it's just the way in which the tables are structured. So for 15A and 15B, because the first rule that applies is the restricted discretionary activity status, the matters over which discretion is restricted are listed in that middle column. And so.
Oh, sorry, it is, yeah.
Yep.
Yes, I see what you mean. You've added them in, yep.
Yep.
And you've, in fact, that's one of the corrections you made this morning, wasn't it, to number 1? Yes, okay, sorry, that was.
No, that's okay.
Okay, and so you're saying that they have some origin in Rule 10 and you've added to them also?
That's right. And they align with the matters in 14 and 15, as you've picked up.
Yeah, sorry, my bad there. I completely understand what you're saying there.
Yeah, no, it's okay. It's as you say, a sea of red and blue, and
yeah.
Yep.
Okay. That was all for me, Stephen.
Yes, thank you, David. I was struggling with that as well. I think you've added the word particular into matter 1, which is not in H4R10. So apart from that.
Yeah, in particular is in the officer's recommended changes for
Right.
14 and R15.
So that's, yes, we have to work our way through the colour coding. All right, I think we've covered all our questions. And is there anything finally you'd like to say, either from a planning perspective or Karen from a legal perspective after listening to the questions?
Not from me. Thank you very much.
Thank you.
Just thank you for your patience today. I realise that some of that was a little bit confusing
Yes.
today.
And you've carefully worked your way through that. So in the text follows those changes. So thank you again for that. And we will break for morning tea and be back at 11:45. Thank you very much.
Thank you.
Okay, we're back online. And the next speaker is Mr. Twigley on behalf of a number of submitters. And I think Mr. Harris and Ms. Church may be with you. Cam, are you there?
Yeah, kia ora koutou, I'm here.
Hello. Is Mr. Harris and Ms. Church with us as well?
I believe Mr. Harris is. I'm not sure about Ms. Church.
Okay. So Luke, just turn on your video. There you are. So yes, Kim, I think there's a statement from you, but also something from Mr. Harris as well.
Yeah, I'll probably start with a procedural matter.
Yes.
I've realised that Mr. Harris's submission actually relates to hearing 14 and Schedule 3.
Yes.
I was trying to find the information, and I had to go back to my office and grab out the folders and Mr. McMurdy's evidence, and I was thinking we must be dealing with both the archaeological site and the SESM at the same time.
Yeah, so it's the site on Mr. Harris's property is just an archaeological site. It's not a site of significance to Māori. So I guess Mr. Harris is here, and we're prepared to talk to the issues, but it does relate to hearing 14 rather than hearing 13. So I guess we're in your hands on that. We're happy to come back next week on that one.
Yeah, I think just to keep things tidy, Cam, that would be best.
Sure. So you're off the hook, Luke.
Thank you. Thanks, guys, for the time anyway.
Yeah, we'll see you next week, I think.
Cool. Ka kite.
See you, Luke. Okay.
Okay. So Rachel's not there. She hasn't tuned in.
Not that I can see, Cam.
Okay. All right. No, that's okay. So yeah, I'm representing a number of submitters whose properties were impacted by the Heritage Taranaki submission. I wasn't tuned in yesterday, but I believe Heritage Taranaki spoke to their submission. So you guys are probably well across the background to their submission and the further submissions that were made.
Yes, we had Mr. Bruce talk to us on behalf of Heritage Taranaki, and just so you're aware, he was going to go away and perhaps provide me with a list of ones he particularly thought on their list that aren't in the plan that would be worth us visiting, but I'd have to see that list and then make proper arrangements if we did want to have a look at any of those. So just so you're aware, he said I've got the feeling it would be perhaps a highlights list, so we'll see what he comes back with, and we'll make that available if there is a request and let people know what we're doing.
Okay. Thanks for that. Yeah, so out of the submitters that I'm representing, the only submitter that wished to speak was Rachel, and I'm not sure why she hasn't tuned in, but hopefully she will soon. So from a planning perspective, my concern was around the process rather than any debate about whether particular properties had heritage value or not. So yeah, very aligned with the Section 42A report from Ms. O'Byrne around good process around listing heritage properties and the importance of consultation and engagement with those property owners over a period of time, so that they can understand the values of those properties and the reasons for listing and the impacts of that a listing will have on their future use and enjoyment of their property. And also fully agree with the Section 42A report in terms of the importance of those assessments being carried out by heritage experts, qualified and experienced people. And yeah, I highlighted the point in my evidence that where those processes aren't followed, it can result in perverse outcomes. And I have seen those throughout my career where things like significant natural areas are proposed on properties, and landowners have moved to remove vegetation before those provisions come into effect because they've felt threatened or haven't fully understood what the implications would be for them. So yeah, that's my concern, where these types of good process isn't followed around these types of matters. So yeah, in conclusion, I agreed with the Section 42A report that the Heritage Taranaki submission should be rejected, and that the appropriate process would be, I think, via a separate plan change process where there was an opportunity to follow this good process. and I'm not trying, I have a lot of respect for Ivan Bruce and Heritage Taranaki and their work and what they're trying to do. I'm not trying to devalue that, but I just think in terms of process, it's yeah, it's not the way to go about things.
Okay, Cam, do you think your clients, is there anything particular about any of the buildings or sites that you'd like to highlight? Is it just a general process issue? There's nothing we should be thinking about in terms of values or anything else at this stage? That's up for Heritage New Zealand to approve or show? Yeah,
no, nothing in particular. I haven't got into that level of detail, and the submitters wanted their submissions to sort of speak for themselves, apart from Rachel Church, who did want to appear and speak to hers.
Yes. Okay. Well, look, I think that's clear. The 42A report did spend quite a bit of time just working its way through the process. We did hear from Mr. Bruce yesterday that they've been in dialogue with the council, quite a bit, and in their view, there's still quite a lot of way to go. And yes. So, any questions for Cam, Antoine?
Cam, I'm not sure if you were with us yesterday. I don't think you were. We had a number of the experts from Heritage New Zealand providing their submissions. And it was short time after the ones from Heritage Taranaki. But particularly the Heritage New Zealand submissions, they were quite comfortable with the approach that Section 42A officers were taking in regards to a large number of buildings and structures in some areas that had been recommended by Heritage Taranaki, with perhaps the exception of a few sites. And I just wondered, there was one particular site, Tongaporotu Batch areas, and I just wondered whether any of your clients that you're representing, the submitters, were owners of or occupiers of any of those buildings.
No, they aren't.
Okay, let's go. Okay, that's fine. Yeah, I didn't have any further questions.
David?
Yes, just a couple from me, Mr. Twigley. The first is, and I may have the numbers wrong, but I think Heritage Taranaki had recommended some 35 additions. The number's not important, but I'm just wondering, at some stage through the hearing administrator, would you be able to advise the particular properties that your clients are concerned with? And just a list. I mean, I'm guessing they're not all 35 that have been identified. It's you've got a handful of clients, and presume it's a handful of properties. But it might be useful to have knowledge of what those properties are, in light of what the chair said about the highlights list that Mr. Bruce might be providing later on.
Sure. Yeah, I can do that.
Yep, just a straight administrative matter. The second matter, and we questioned Mr. Bruce quite extensively about the approach and the process, and whilst he accepted I think the comments about lack of input from the owners of properties covered by his submission, he did make an interesting point, and I wrote it down. He said that knowledge about the heritage value of these properties has been around for a long time, and he felt that a decision or a recommendation or an endeavour to deal with these later on was just kicking the can down the road. And he said that if that was to be the approach adopted through this procedure, he'd like to see some sort of time frame put on that so that it wasn't infinite. And I just wondered whether you had any comment on the appropriateness of a time frame for this future exercise, because it seems that some of the properties, and I'm not necessarily talking about your clients' properties, might qualify for inclusion. I think Mr. Kelly and Mr. Murray have indicated that from their very cursory glances, some of them might. And the same applies to notable trees too. So Mr. Bruce was worried that if the process took too long, then the resource that we're dealing with might disappear. Any comments?
Yeah, I mean, I can understand what he's saying there, that, you know, there will be perhaps a percentage of those property owners that might seek to, you know, remove a building, relocate it somewhere else, or alter it substantially, you know, in the interim period. But I would think that the majority of the property owners would value any sort of heritage aspects that their properties had. You know, that's, you know, certainly the ones that I'm representing, they do appreciate that their buildings have some heritage aspect that they personally, you know, are attracted to. So, but yeah, I think it's really more about the process for them rather than,
yes,
you know, an argument about whether it should be or it shouldn't be.
So in that sense, it doesn't necessarily follow that they might be opposed to a listing. It's how that listing might come about that they're more interested in pursuing.
Yeah, and you know, having a decent opportunity to consider and understand what that listing might mean for their property, whereas the process that we've had to date, they got an unexpected notification from the council that that the Heritage Taranaki submission had been received, and they had 10 working days to respond to it. So
yes,
yeah, as you can imagine, that can be pretty disturbing.
Yes,
if
we've
you
heard from a number of submitters yesterday telling us that directly. So yes, we do understand.
Yep.
These sort of exercises are very resource dependent, and I know the planning team have got a lot on, but what's your expectation of what a reasonable time frame for this sort of exercise might be? And it may be that it doesn't result in a first schedule process, but it might also. Are we talking months or years, or what?
Well, I mean, if we're talking 35 properties, and obviously, you know, our heritage experts would need to be engaged to go and do assessments on those. You know, how long would that take? You know, maybe 6 months, something like that, might be a reasonable time period to get that work done. And then, you know, a reasonable time to engage with those property owners might be, there might be another 6 months, I suppose, or it could be slightly shorter. So yeah, we're probably talking in the order of 2 to 3 years, I suppose, you know, when you look at a full process.
Certainly post any decisions that are released on the plan. Yes.
Yeah.
Okay. And I may have the metrics wrong. 35. I'm not sure where I got that wrong. We've got that from, but that may have been tree numbers. I'm just not too clear. But that you understand what I'm saying?
Yes, I do. Yeah.
Matt, perhaps we just get an update on that number, because Lauren or Joe, how many extras were Taranaki?
I think it was about 91 heritage buildings and about 100 archaeological sites.
Yes.
Okay, right. Thank you for that clarification. I have no idea where I got the number 35 from. Maybe that was trees. But it was certainly a significant number. Yeah. Stephen, that's all from me. Thank you, Mr. Twigley.
Yes. Look, I don't have anything else. Cam, thanks for coming and representing your clients, and it's always very useful to actually have feedback, particularly on where the Puritae report team have got to from yourself as a planner. That schedule list of the properties that you're representing, yeah, so just get that through to Christine or Julie over the next few days would be great. Thank you very much.
Will do, and yeah, Luke and I will be back next week.
Okay, we'll see you then.
Okay, thank you.
Bye-bye. Right, we're moving now to Helen Johnson. Johnson for Johnson Resource Management. Welcome, Helen. Thanks for
Good morning.
attending again. Good morning.
So you would have had my written evidence.
Yes.
In the main, again, the submission is about workability of the rules and clarity and those sorts of things. And in the main, I generally agree with the recommendations in the Section 42A report. Just flitting through them briefly, rules HHR2, HHR3 and R4, which relate to the erection of a structure, installation of an impervious surface and relocation of a structure. Ms. O'Byrne and her team have done an awful lot of work to identify heritage extents, and I appreciate the work that's gone into that. And I also appreciate the difficulty in writing a rule that fits all circumstances. So while I'm not completely comfortable with it, I support the work that's been done on that recommendation. Rule HHR6, my submission point was addressed, just related to a drafting error. Rule HHR17, which related to earthworks on or within 50 metres of a scheduled archaeological site. My submission was basically concerned about the inconsistency between the rules pertaining to earthworks compared to structures, that the earthworks rule essentially made the permitted activity status of the other rules defunct. So the reporting planner has recommended some changes based on the different ways in which the sites are identified, being mapped, identified and silent. And under 17, I've just noted how those rules have been reworked. So I think the inconsistency has been addressed, but I did have some concerns with the way in which the rules were written. Personally, I found it a little difficult to get my head around the rules in the way that they were written. And so I've suggested some rewording for that I felt made the intent of the rules and the matters that needed to be considered or met the criteria to be met clearer. I noted that there appeared to me to be a gap in the rules for the identified and silent archaeological sites, being that area between the site and 50 metres. And I also noted that there was some apparent contradiction with regard to references to earthworks, where the exemptions and the content of the other rules appeared to sort of contradict each other. So overall, I support the approach that's been taken. I just think it needs a weeny bit of tweaking. The main issue that I'd like to talk to you about relates to Rule HHR 18, which is subdivision of land containing any part of a scheduled archaeological site. So the main issue that I have is, I guess, an issue that I've raised with regard to other things such as indicative roads, where the rule applies to the site as a whole. And if you have a large site with an archaeological site in one corner, that could pick up a subdivision at some substantial distance from the site as a discretionary activity. To my mind, my understanding of the 50-metre setback that one of the, I think Ms. Cavell referred to earlier, is that it relates to the setting of the archaeological site. And so you have the rules that control earthworks, structures, those activities that are actually likely to potentially impact on the setting of a structure. The setting of an archaeological site. So to my mind, I felt it would be more equitable to have a similar approach taken for subdivision. I've suggested in the appendix to my evidence how I think that might be achieved, fundamentally just relating it in a similar manner to the rules that are written that have those setbacks. I would note that policy HHP 15 refers to activities on or in proximity to scheduled archaeological sites. And I think that reiterates that it's about activities that are likely to have adverse effects on the values of the archaeological sites that the rule is intended to capture, and to have the rule as written brings in activities that wouldn't necessarily adversely affect those for reasons of distance. So that's fundamentally my submission. Thank you.
Thank you very much, Ms. Johnson. Ms. Commissioner Coffin, do you have any questions?
I didn't have any questions per se, but I was just looking at your appendix 2. I was just wondering if you'd be so kind just to take us through those changes that you've recommended, just so I'm really clear about them, particularly the ones on the next page over where you've got some question marks, and just whether you had any thoughts about those.
So what I've done is basically in the recommended changes to the appendices, there's a lot of information contained in those upper parts.
Yes.
And so I've pulled the bits that I consider to be criteria out and set them within the actual bit under the permitted status. The bits that I've highlighted is where I'm not sure what the intent is. So for example, if we have a look at the first ones, I've got but within 100 metres of the extent of an identified archaeological site. I'm assuming that it's both within 50 metres and within 100 metres for those ones that they want to control the height of structures. So that's kind of extrapolated from what's in the current rule. With regard to HHR 27 and R28, which is earthworks on or within proximity to a scheduled archaeological site, again, I've pulled the criteria down into the body. I guess the earthworks that are associated with the maintenance and repair or upgrading of a network utility provided for as, I'm assuming it's provided for as a permitted activity, because it could be argued that it's provided for by a rule, and even if it's a controlled activity, you're permitted under here. So just to clarify that it's the permitted, it has to meet permitted activity status under those rules. And just having a look at what they've got in those rules, if you'll bear with me for a minute. So HHR 14 to R17, which is maintenance and repair of network utilities, has a permitted status that says under 1A, the maintenance and repair does not include land disturbance or earthworks. So that to me kind of is contrary to what the intent of HHR 27 and R28 are trying to achieve. I admit to confusion. I'm finding it difficult to suggest how it might be amended because I'm not quite sure what they're trying to achieve.
Yeah. Thank you. Okay. Yep. I've just caught up with you. Thank you. David?
David?
Yes, good morning, Ms. Johnson. Good
morning.
to see you back again, and casting your fine eye over the provisions from a practitioner's point of view. So thank you for that. I really found your table in Appendix 1 to be really useful, as sort of what I would call a sort of a wiring diagram of whether there are any gaps or not. And if you turn over to page 9, obviously you've identified a couple of those gaps. And yesterday I was wondering whether there might be a gap also. And you've touched on it in relation to your paragraph 20. So are you suggesting that there is no control over structures erected or altered or relocated within 50 metres of an identified or silent site? And even though that might have been the intention.
I guess that is what I'm saying.
Yes.
There is no rule for it. So
Yes. Okay. Have you haven't provided a potential rewording of that, have you? And similar to what you've done in Appendix 2, you've just identified it as a potential issue.
I have fundamentally because I didn't actually submit on those rules, I only submitted on the earthworks one. I have got a suggested rewording, I think, from memory, but I didn't include it.
Okay, right. So that could be an unintentional outcome of the wording of that rule.
That's what I understand, yes.
Okay, thank you. We'll hear back from Mr. Byrne on that. Okay, I think I understand what you're saying about H 27 and 28. I'm going to have to give that some further thought. Thank you for your suggested wordings, and I'm sure the officers will appreciate giving that some consideration and coming back to us. So I'm going to leave it for them to respond in due course.
Thank you.
Thank you, Stephen.
Yes, thank you. And I have no further questions, but do encourage some ongoing dialogue if there's a lack of clarity between you and Lauren and the team. Helen, I'm very comfortable with practitioner discussions around clarification on the detail you presented your issues. These are quite technical planning matters, so if there's some assistance to get on the phone and have a quick chat, I'd encourage Lauren to do that if she needs to, rather than doing that sort of in the context of the hearing. Unless there was anything particularly you wanted to say, Lauren. Okay. Thank you for your attendance. Very much appreciated as always.
Thank you.
All right. We're now moving to Georgina McPherson for LINZ.
Good morning.
Morning.
Can you hear me all right?
Yes, you're loud and clear, Georgina.
Excellent. Okay. I'm sorry, I have logged in more recently. I didn't pick up the very beginning of the hearing. I'm not sure if you want me to run through a brief summary of my evidence, or
Yes.
if you just want to respond to respond to questions.
Okay. Yes, please. And I'm wondering whether, you're talking mainly about the Barrett Street versus home, is that right?
Yes, that's correct.
Yes. I wonder whether we could get the Google image up on the screen, so we can just orientate ourselves. I think you're quite familiar with the site.
Yes. Yeah.
Yes.
In fact, some one phase of the works on that project have just got underway there last week.
Yes, there's some press about that, wasn't there?
Yes, there was.
Once we get the site up, wouldn't mind just a little geography lesson from you, if you can do it, with reference to the plan that comes up, just so we understand where, particularly I think where the east wing is, which is where the heritage values are. Is that correct?
Yes, that's correct.
Hey, Stephen, I'd really appreciate that, an aerial view. Unless we can get a live satellite feed, that would be even more amazing. But in the absence of that, and if there is a street view or a view of
we're just working on that now.
Yeah, I don't know if it'll show the eastern wing.
Yeah, right. Yeah. That's good.
Down there. And it's round the side. Come this way. The other direction? It's there, isn't it? And then I go down there. No, no, no. Go
that
in
power
opposite
street's
direction.
there.
And keep one more clip. And then maybe spin it around and look back at it. Cool. It's good.
That's great.
Thanks, John.
Thank you. So just as I say, an introduction for us would be really helpful because we do have some other evidence on this this site.
Yes. That's a really great view of the eastern wing there, sitting in behind the building with the red roof. And the vast majority of buildings on that site have now been removed. And it was essentially just the heritage structures that have been left intact in those parts of buildings that needed to remain to avoid any removal of heritage material. Those other buildings weren't protected. Just as a bit of context, which I'm sure you will be aware of from reviewing both my evidence and that of Te Kotahitanga who are coming up, I think right after the lunch break. This site is treaty settlement land. It's currently sitting with LINZ in the Treaty Settlement Land Bank. It is going through a process of negotiations between LINZ and Te Kotahitanga around a potential purchase of the site. They essentially have a right of first refusal, but there are a number of processes underway before that, and I'm not going to get into those details because they sit outside of the resource management process. But at the current time, LINZ and Te Kotahitanga have been working closely together on a program of decontaminating the land with the overall intent of delivering a clean and clear site. So this a resource consent has just last week been granted, and those works are now underway to remove all remaining non-heritage structures from the site. That includes a number of retaining walls, foundations of some buildings that haven't yet been removed. Demolition on the site started several years ago, but wasn't able to continue because of the extent of contamination that was found. And they needed to go back and get consents in place for that. A lot of the material was just left in stockpiles around the property, and removal of those stockpiles is provided for by this consent. It's been an issue that has hit the news a number of times in the past few years around the state of the site, and the remaining heritage building there has been vandalised and degraded over time, and there have been various incidents of people getting through those security fences and entering the building and disrupting neighbours, various unsocial behaviour going on.
So the contamination is mainly asbestos, or is there a mix of things, just as context?
So across the site, there's quite a mix of things because it was an operational hospital. So you've got things like the ambulance bay where there was an underground storage tank. There was various mechanical substances held there, oils and the like. There was a swimming pool, so there's areas of chlorine contamination around that.
Yes.
An old morgue, so areas of contaminated land around that.
Yes.
The remaining heritage building here has a lot of asbestos in it. There's also been a dangerous and unsanitary building notice issued relating both to the asbestos and the structural condition of the building.
Yes.
And that's, that is probably reflective of the state of the buildings that existed prior as well, though this one's been there for several years longer now to have had more time to come to be in the state it's in now.
Yes. Right, and just the general facts about the site, the overall site, just its overall size, roughly. Quite a large site, isn't it?
It is quite a large site. And I should know that figure off the top of my head, but I'm drawing a complete blank on it at the moment. I'm sorry.
Yeah, that's all right.
It is several hectares. Yes. It's also the site of a former pa, Maikuku,
yes.
and that's something that Te Kotahitanga will be able to speak to more and speak to their connections and the importance and role of the land to them.
Yes. So the block here, that hasn't been used for quite for many years, has it?
No, it hasn't. I understand. I haven't been heavily involved with looking at the specifics of this building, but I understand it was came out of use in the sort of 2000s, and then it's once that insanitary building notice was issued. Sorry, I've got that attached to my evidence, the date of it, in 2013. It certainly hasn't been used since then, but it was disused for many years before that as well.
Yes. All right. Okay. Well, thank you for that context. So, if you do want to summarise the gist of your evidence, you do have a good executive summary, which you might want to read through. However you like to roll, that'll be good.
Sure. So, the submission from LINZ was to, I guess, carve out a different consenting approach for this building and to apply a discretionary rather than a full non-complying activity status to demolition, removal or relocation activity. And as I've worked through in my evidence, I don't actually support that specific relief that's sought, but the LINZ submission raises some very interesting issues around this land and the various tensions and relationships around the future of the site. It draws attention to the layers. There's obviously the heritage values associated with the former nurses building itself, which is the subject of this hearing, has the heritage protection associated with it. And that's not something that LINZ is challenging in any way. Council's been through an appropriate process in terms of assessing the values and rating them and notifying that through the plan, and it's come through from the operative plan as well. But along with those heritage values, there are significant cultural and heritage values associated with the site of significance, the Otumaikuku Pa, across the land. And there are also some significant constraints around how this piece of land will be able to be used and developed in future, given its history and the level of contamination that is currently there. And that's one of the things that is being addressed to an extent through this current consenting process for the decontamination works. I think that in order to, I said I don't support that specific relief of a discretionary activity status, but I think that there are a number of elements that make this site unique and that speak to there being a need to be able to recognise that through a consent process that will inevitably come up at some stage to enable the future use and development of the land. And I think the key thing in that space is going to be ensuring there's an appropriate policy context to allow those considerations for a consent process. And looking at and unfortunately the scope of Lynn's submission doesn't actually relate to any specific policy wording, but in that context of there being a need to enable some sort of development through the policy framework, policy P7 in this section appears to be particularly key to that consideration. There does appear to be a drafting error in that the clauses in the track change version, the section 42A report, are now linked by an and rather than an or in the original notified version. And that has some quite significant implications in terms of how those, in terms of whether all of those things could be met by an application. And I don't think that's actually possible because some of the clauses relate distinctly to removal in part, and some relate to total demolition. And so I've just lost my wording of the policy there. And I think that that is actually acknowledged in the section 42A report as well. There are other references to the way those policies, clauses in the policies are linked. And I think there's quite a clear steer in that report that the intent is for these policies to, these clauses in the policy to be linked by an or. The policy framework also includes policy P3, which appears to conflict with policy P7 in that it requires the avoidance of demolition, removal or relocation in all circumstances. And whilst you might come up with an argument through a consent process that you look at the more specific policy, which would be P7 in this instance, that does provide an avenue, I think that you've equally got a counter argument that the more restrictive approach has to apply, and you may well get that sort of outcome, as particularly if a consent was to go through an environment court setting. But at least I think that it's confusing, it's inefficient and ineffective to have two quite conflicting policies in a set of policies applying to heritage buildings. Whilst I would just note that that approach does appear to extend across to the sites of significance provisions as well, where there's a sort of a generic policy up front that requires avoidance of effects in all cases, and then the subsequent policies provide a more specific breakdown, which actually does provide appropriate avenues for consideration of various activities, but that you're left with this overriding conflict and confusion as to how you should be working through that in a policy context. So I have included some limited alternative wording in my evidence that I think that I consider to be within scope of Lynn's submission in terms of ensuring that there is that appropriate policy pathway to enable a consideration and balancing of the various competing interests in future development of the site. but recognise that things probably could go further along that track as well, but that's outside of the scope of where LINZ is able to go at this point. So I'd be happy to respond to any questions, either more on the context of the site or the evidence.
Thank you. Were you here yesterday when Mr. Raymond gave evidence for Heritage New Zealand?
No, I wasn't.
Okay, so we did, he had some particular issues with P7 as well. Oh, sorry, yes, P7, right, largely around the question of about this term significant public benefit and how that might sort of counter some of the very prescriptive parts of that policy. And we had agreed that some dialogue amongst the planners, all the planners interested in this, these provisions would be helpful, and Ms. O'Byrne is going to organise some form of discussions after the hearing just to assist with clarifying the planners' positions on this. So I presume you'd be comfortable just participating in that process?
Yeah, sure. And look, I agree that interpretation of that term significant public benefit is quite significant, but also hugely uncertain. I'm not sure what it would necessarily mean in the context of these policies here.
Yes.
I'm aware of a couple of other plans that do use that term significant public benefit in the context of considering heritage buildings.
Yes.
I know the term's also used in NZCPS in terms of looking at significant public benefit of placing hard protection structures on public land where they're to protect private assets. But I'm not sure there's a lot of case law. I've struggled to find anything that clarified how that term had been used in practice.
Yes, he did highlight some new provisions around fast track consenting where that term is used. So you have a look at the evidence, I think, but yes, so I just wanted to make that connection before we go to specific questions, which we'll start with now. Antoine, did you have any, or you have some questions?
I've actually appreciated the interpolation of the submission, and I suppose I just want to acknowledge you being really upfront around the scope of the submissions that LINZ had made, and that in the narrow scope you had in terms of what you were seeking in your evidence. So that was appreciated. That's not always the case with evidence that we have in front of us, so I just appreciated you being very upfront about that. And also having the view that may be slightly different to what was, or your view didn't necessarily support what your client was seeking in terms of a consenting pathway. So I just appreciated you just setting that out, what that was, and also highlighting the particular, what appears to be a particular drafting error or just a disconnect between those different provisions. Yes, that's appreciated. I suppose most of my questions are actually to do with the building, and they're probably not questions you can answer, but we may be able to get some response from experts from council around at what stage does a heritage item, in this case a building, in terms of its physical condition, no longer is able to bear the significant values that have been associated with it, because it's been clearly identified as being in poor condition, and certainly from our view from the side of the street, that's certainly the case. However, the experts, particularly Murray and Kelly, have confirmed that regardless of its poor condition, those heritage values still exist. And I just wondered whether that's the case, even if the building wasn't there, would those values still be there? It sort of begs that question. and whether that's something that should be considered now, or are those the types of issues that would normally be considered during a consent process?
Yeah, well, in my opinion, that would be the appropriate place to consider those things. And I wouldn't, I'm certainly not qualified to challenge the heritage values that have been identified, but I don't think that there's a need to, because in this case, I think it's clear that there are heritage values associated with the building. It's got a long association with that site, with the hospital. It was then used for various community-based activities. So I understand that a lot of people across New Plymouth will have been through that building at some point in time. And that's where I think that clause in the policy that provides for demolition if it is necessary to prevent serious threat to property, people or services is really key. And that's where I think it draws it into a consideration through a consent process. So I'm aware that all councils are required to have a policy on the interface between a dangerous and insanitary notice issued under the Building Act and heritage buildings. And in this case, the New Plymouth Council one is clear that the dangerous and insanitary notice doesn't override the heritage status. So the fact that there's a notice there doesn't automatically mean it no longer has heritage values, or that it justifies on its own, justifies entire removal of it, because there may be some options there. And it obviously depends on the state. It depends on the reason a dangerous and insanitary building notice was issued. That can range, and a building inspector would be much more familiar with the specific reasons, but it can range from something like stormwater and wastewater type issues, which could be remedied relatively easily, through to quite significant structural and contamination issues. And my sense is that this building sits more at that end, but I do think that the appropriate time to have that conversation is as part of a consenting process, where there's an opportunity to get to specifically look at the building, the merits of what might be presented as a proposal, whether it's full or partial demolition, the extent to which any sort of material can be retained, any ways, if the answer to that is no, any ways of retaining the heritage values in another way through signage and placards and that sort of avenue. But in short, yes, I think the consenting process is where that level of detail needs to come up. I think it would be difficult. I think it's difficult to do that at a policy level, and I know that councils across the country are reluctant to, because they don't want to set up a situation that encourages building owners to let their buildings run into disrepair, and that then gives them an easier ride through a consenting process.
If I was going to ask you one question, it's probably whether you had a view about any unintended consequences of on the face of it, small wording changes might make. And we've had a number of submitters on behalf of particular scheduled items, or opposed to particular heritage items, said, oh, if we have a little tweak here and a little tweak there, that provides us with a pathway where we can do some upgrades or some maintenance, or make some changes to the building without too much impediment. So I just wondered whether you had a view around unintended consequences of those changes which you've recommended. That's at 7.2.
Well, I haven't reviewed those other changes from other parties that you're looking at, that you've referred to. And I guess I've tried to restrict the extent of suggested changes, mindful of the scope. So I don't believe that there would be unintended consequences of those particular changes. where I've tried to go with it is that it reverts to what was set out in the notified version of the policy, where you could meet one or the other of the clauses rather than all of them together.
Okay.
And it separates, in clause 3, separates total from partial demolition, because the requirements in the clause can really only apply in the case of partial demolition. If your proposal is to totally demolish a building, then you I don't think you can be retaining the fabric itself. I think there's other ways of retaining the values without necessarily retaining the structure and the fabric of that. But my reading of that is that the clause requires some part of the structure to be retained, and you can't do that if you're totally demolishing a building.
Thank you. Over to you.
You're up, David.
Yes, good morning, Ms. McPherson. I've been listening intently because there's quite a number of themes here that relate not only to your building, but to the heritage chapter in total. But before I get on to those, just in terms of the listing for the site, is the total site listed, or is the separate buildings on it listed separately? Can you assist in that?
So this is it's only this one. So there's this one building that is listed for the site.
Okay.
And then separately, there's a separate listing for the fence and gates.
Yes.
On the site, and that was introduced to the operative plan through a subsequent plan change.
Yes, and
they've
that's
both been being carried through to this. But the rest of the site is not listed as a heritage building or structural place, and the eastern wing of the former nurses' home doesn't then have a I'm sorry, I forget the terminology used in this plan, but it doesn't have a setting associated with it that extends the extent of the protection beyond the building itself.
Okay. You mentioned that a resource consent for the removal and demolition of non-heritage buildings on the site's been granted.
Yes.
Yes. So presumably they weren't what the plan refers to as contributory buildings at all.
No.
Okay. And the gates and the brick wall, I think that's site ID 103. That's the site that's captured by the restricted discretionary activity status in the plan. Yes. Can you speak to the rationale for that activity status for that component of the site?
A little bit. I wasn't involved in the process that went through, but my understanding is that there was already a restricted discretionary status category in the plan that provided for a couple of other items that are, I think, a well and another set of cemetery gates.
Yes, you've covered that in your 5.7. Yes.
And so I understand the rationale there was that they were items that could comparatively easily be picked up and relocated while intact, retaining the value of the structures themselves, as opposed to, say, relocating a large hospital building. But it was very clear in the material around the introduction of the Barrett Street gates and brick wall that that decision was complicated by the treaty settlement status of the land. And I haven't had an opportunity to review the Section 42A report that went along with that. That I might have gone into a bit more detail on those issues, but I think
that's fine. The context you've given is sufficient. I was just trying to understand whether it was a single listing or multiple listings and whether there were contributory buildings. Sounds like it, apart from the gates, it's a single listing and there's no contributory buildings.
Yeah.
Okay. And the restricted discretionary activity is solely in relation to the relocation of those.
Of the gates.
Yes, not the partial demolition or demolition.
Yeah.
Okay, that's good good to have the facts right. The wider area that I wanted to have a discussion with you on relates to the activity status of non-complying activity status under rule, I can't remember what rule number it is, but that it draws on policy P7 as a guidance for non-complying activity. And I was interested to see that you didn't support the relief sought by LINZ, and on day one of the hearing, I actually asked the officers about whether there'd been any submissions in relation to non-complying activity status per se, and obviously with the exception of the LINZ one, which seems to be site specific, the answer is no, there isn't, which surprised me actually, given my experience in other decision-making forums involving the demolition or partial demolition of listed buildings which have struggled to get through a gateway test, compared to some situations where they've been listed as a lesser activity status, discretionary. And I can think of two in the last year that I've been involved in as a decision maker, which have had quite different outcomes, both as discretionary activities. One was approved and one was declined based on the merits of the case. Discretionary activity status as a technique wasn't seen as a impediment to decline. Didn't seem to be necessary to have non-complying activity status to do that. You could still draw on policy. And the plans that I'm dealing with there were the Pororua plan and the Palmerston North plan, both which have similar provisions, but as a discretionary activity. So I was really interested to hear that you weren't supporting a move from non-complying to discretionary for this site. Is there anything further you'd like to say in relation to the reasons for that?
Well, I think I actually understand that there was a submission from Te Kotahitanga which sought a restricted discretionary status across the board for all demolition of all heritage buildings, and not specific to this one. So I do think that there is one in the context of this plan. But look, in this case, I certainly gave a lot of consideration to whether I could support that position in the submission. And it looked to me like you really need to be able to draw a very clear line around this one building to set it aside from everything else and its context. And at that point, I think it requires quite a comprehensive review of all the other buildings and sites to ensure that you've got the one that has that set of circumstances apply to it.
Yes.
And certainly in this case, we've got a submitter who's standing up and saying these situations are unique here. Yes. But I am not aware of, I haven't been through that process. I don't know if there are other buildings in the heritage listing that would be in a similar state of disrepair that you might be able to say, well, this also warrants a different approach because of its condition. And also I think in this case, the issue of, so I haven't looked either at these settings to know whether there's also an interface between treaty settlement land or sites of significance to iwi that are listed in the plan, but then treaty settlement land is something that sits outside of the district plan framework and might come up in future on another property, and would then suggest that you should be taking that same approach.
Yes.
Yeah.
So what I'm taking from your answer there, Ms. McPherson, is that you found it very difficult on a single site basis to recommend a different activity status, given that the site characteristics of this site may not be different from a number of other sites that are also subject to the non-complying activity status. That's my synopsis of your answer.
Yeah.
Okay.
Yeah.
And
I think, sorry, I was going to say, I think I think even if you have a discretionary activity status, you've still got that bigger issue of needing to get through the policy framework.
Yes.
And whilst if you're discretionary, you of course don't have the gateway tests to meet, you've still got potentially a restrictive policy framework to work your way through.
Yeah,
And so to me,
under 104.
To 104. To me, that's the bigger issue, is
Yes.
ensuring that the policy framework provides that pathway
Yes.
to pick up on all those various considerations and allow that balancing to happen as you're going through a consent process.
Yes, that's a very interesting position. And what I take from that is, and I don't mean to belittle the difference in the activity status, is that it doesn't really matter, or you don't really need a non-complying activity if you've got a strong policy or a directive policy or an appropriate policy that enables you to decline an application on its merits.
Yeah, I think that's true.
Yes.
You know, and I think that's been signalled for where things are likely to go in the national planning standards, that
Yes.
non-complying status might be done away with.
Conversely, if you do have a non-complying activity status, then all roads lead to the policy to determine what should be the appropriate decision in the circumstances. And in this case, you've identified two policies, P3 and P7. And like you, I'd ascertained an inherent conflict between them. A largely protection focus of P3 with I guess you could call it a qualified avoidance in P7. Avoidance unless certain things are proven. But even then, I think you're saying P7 is not perfect because it really doesn't provide a policy pathway for demolition, only partial demolition. You indicated that in relation to clause 3. So in light of the relief that you're supporting, which is a change to P7, aside from making the clauses disjunctive rather than conjunctive, what other changes would you see as being necessary?
Well, I think, as was flagged earlier, I've read that clause around the significant public benefit several times, and I just think that you could get a lot more clarity out of what is intended to be achieved by that clause.
Yes.
Yeah, I think in the context of this site, it would be useful to have a clause that provided that sort of steered you towards that specific balancing of the other competing interests.
Yes.
And in this case, it's the site of significance to Māori, which is also protected at a very high level, but you've got a discretionary activity status there for works on those sites. So potentially you're picking winners at this stage already if you're non-complying for removing or affecting heritage structures in this part of the plan.
Yes.
So I
was going to say, notwithstanding that potential reworking of clause 1 and the concept of public benefit, excuse me, I'm taking from your evidence that you still think there's a policy gap in relation to total demolition that falls somewhere between clause 3 and clause 4.
Yes, well, although I think that could be covered by clause 2 as well, if your building is in that category of potentially causing serious threat to property, people, or services. And I think health and safety sits up in section 5 of the RMA as an overriding factor or significant factor. Sorry, nothing's overriding. And I'm aware that there is a bit of case law around that in the context of heritage structures where there is very significant risk to health and safety.
Yes.
So in the case of this building, I would anticipate you might be able to look at these sorts of activities under that clause. it probably would be useful to have something else in there that along the lines of clause 3 that require the preservation of the values in some shape or form,
Yes.
without the structure itself.
Yes, and clause 3, you've suggested the deletion of the word total, I think, which might seem counterproductive to what you're suggesting, but I understand why you've done that, because the rest of the clause goes on to really talk about partial demolition, doesn't it? That doesn't really address total demolition. Yes,
Yeah.
and whilst I take your point that clauses 1 and 2 in their general sense could apply to total demolition and would be drawn on by an applicant, I can say that as a decision maker, commissioners quite often look for a specific policy guidance in respect to what's in front of them, and in this case, that policy seems to be reasonably silent on total demolition, other than what can be gleaned from clauses 1 and 2. Okay, I'm just conscious that I should be asking you questions, not giving you my opinion. So I'm going to leave it there, but I guess through you, Stephen, I'm obviously sowing a seed here that I'm really keen to hear the officers respond to, and they're right of reply, and that is basically the appropriateness of non-complying activity status per se as a technique to giving effect to the policies and objectives of the plan. And both in terms of the earlier thing that I introduced about an activity status should be the one that is the most efficient and effective in delivering the outcome, where there is a choice between activity statuses, and that where there is a choice, the plan setting should be the one that is the least onerous. And the other part to that is that regardless of the activity status, what changes need to be undertaken to policy 7 to enable a complete consideration by decision makers at the time of resource consent. So probably said too much, but I'd rather just speak my mind in terms of the issues that are troubling me, and would hope those matters would be addressed in the right of reply. So thank you, Ms. McPherson, for raising that issue, even though it probably goes beyond the ambit of your client's concern.
Yeah, no, thank you.
Yes, thank you, David. And I think you're really just reflecting your experience with some pretty contentious hearings you've had to deal with in the last couple of years. That one in Palmerston North, where policy, I think the direction that I have, and I'll be interested in your feeling, Georgina, is that the courts are really saying that irrespective of activity status, discretionary versus non-complying, the wording of the policies are just crucial to decision making for them and for us that are hearing first instance as well. There's a number of cases which make that crystal clear from the court's perspective, and I support that. So look, I don't have any particular questions, but thank Antoine and David for covering the ground, and certainly thank you very much, Georgina, for just the sort of the open dialogue that we can have as practitioners together around quite a tricky issue. It's really useful to us as a hearing style to tease these things out and have a good practitioner discussion based on all of our experience. So that's worked so well for us so far. Lauren, is there anything else you'd like to add just in relation to this issue in particular with what we talked to Dean about yesterday? And this was a policy that we were thinking about perhaps putting a few heads together and working through some sort of conferencing. Yes, yeah. Yes,
the only comment I have is that it's obviously a very complex issue, and I don't want to get it wrong, and I think it would benefit from having a few people, different heads, getting together. Yeah, so it's critical we get it right moving forward. Sure. So Georgina, I think Lauren will probably be in touch with you and the other planners that are providing us with expert
advice on these matters, so that can be assimilated in her right to reply any further sort of collaborative thinking on this issue. So thank you for your attendance. Perfect timing. It's about midday, and we now have an hour for lunch. So very well scheduled, Christine. Was there any final comments, Georgina, before we sign off?
No, thank you for the opportunity and for being open to our submissions that went slightly beyond the strict scope of the submission. But yeah, I think that it's really useful to have that conversation around the policy, and I absolutely agree that it's the policy that needs to be right in there, and that maybe the activity status falls in behind that to an extent.
Great, thank you very much. All right, we will adjourn until 1 o'clock and see you back then. Thank you very much.
Thank you.
Welcome back, everybody. Hope you had a good lunch. Got some very squeaky chairs in this room. So, and a very high spec speakers. I'm not sure whether you can hear it squeaking around, but yes. So Marlene, I think we're starting off with you this afternoon. Welcome.
Kia ora.
Kia ora.
Thanks for letting Ngāti Mutunga speak about this. I'm Marlene Benson and I'm speaking on behalf of Ngāti Mutunga. We haven't got very many comments. We support that there's a notable tree register because we think it's important that individual trees or small groups of trees can be protected in this way for cultural or community reasons to give them that value. Being able to protect a tree on the register is really important for Ngāti Mutunga. It's part of which we talked about a bit last week when you came on your field trip. It's part of being able to protect that visual record that Ngāti Mutunga existed in our rohe, and also so that we can get rangatahi to connect where they're from and to know what people used to do and how people used to live. So we were very happy to get one of our groups of trees onto the register. We agree with the Section 48(2)A report writer that the register's sort of swayed towards urban trees, and it does not cover many significant trees in the rural or many trees that are protected for cultural reasons. But we also realise that this would be a really time-consuming job to go through the trees in the district to make this right. We just think you could get a much improvement in this if it was publicised about how you got it onto the schedule and when. I'm presuming you're not going to be able to add any trees onto the schedule till the next plan change, but I think that would be a really good time to sort of make sure that that cover was more representative. We had some misgivings about being part of this process because there's things about those trees in question that we might have not have wanted to talk about, but we found it was handled really sensitively and it was a good process for us and it worked well. We want to really thank the landowners, Carla and Stephen Houghton, because we approached them about this a few years ago and we realised that without their support we probably would not have been able to get the tree in question up Kaipikiri Road into the schedule. I also think that when I look through the schedule, there's trees on there that perhaps have been inherited from other plans or other processes, and it might be a good idea just to check out whether they still fit the criteria. That's all I had to say. Thank you.
Short and sweet.
Yeah.
Yes. So that's great. It's great to see that you're been involved in the process, Ngāti Mutunga, and are supportive of being involved in the future as well.
Yeah.
Christine, before we go to questions, I saw just as Marlene was speaking, Mrs. Church was online. She was the one who came to Wiggly, Rachel Church.
Yes, I had contacted her.
Yes.
And she was able to reply back and she had overlooked
yes.
The date, and then she said she didn't really need to talk.
Yes.
And that I suggested that she gets back in touch with Kim.
Okay, but just let her know if she did want to talk to us. We might be able to sort of have a quick chat
No problem.
later on. But just then I just saw her name on the screen briefly. So yes. Okay. Sorry about that interruption. Antoine, any questions for Marlene?
Hey, kia ora, Marlene. Hey, thanks very much for your submission. I didn't have any questions for you today.
Yay.
But I'm sure I'll have questions for you next week.
David, you're going to disappoint us this time?
Yeah, I'm in the same boat, Ms. Benson. I note your support for the Notable Trees Register and your comments about the additional tree on Schedule 4 with the assistance of Mr. and Mrs. Houghton. So that's acknowledged. Thank you for your presentation.
Thank you.
Thank you very much.
Kia ora, Marlene.
Kia ora.
Kia ora.
Right, moving along.
I just wonder, Mr. Chair, are we intimidating at all? I got the distinct feeling from Marlene, she was a little bit worried she was going to get quizzed and sectioned and stuff. I hope that everyone feels really comfortable with us asking questions. We're just really wanting to clarify things and we just get to understand the issues much better. We're not looking to see whether they're right or wrong or anything.
No, we're I think Marlene's done very well with some questions before on some tricky issues, so she would hold her own with any of us, I think. Yeah. Yes, Sarah. Sorry. Welcome, and thank you for coming in person. Although we did set this as a Zoom meeting, I decided that for my chairing role, it's always much better to be here, certainly with the staff, and we've decided that I'll be here, and some of the other submitters who are more comfortable face to face will be coming along. So that is always my preference. So thank you for coming. Yes, I think there's some preliminary matters with Ms. Bukara and legal submissions. Should we deal with that now?
Yeah, sure.
But do you want to explain what we've agreed, or do you want me to outline?
I can do that. I heard from my colleagues yesterday to let us know, because I hadn't heard from her over the weekend, because we had agreed we would deal with the legal subs over the weekend, so I didn't hear from her over the weekend, and then had an email from her colleagues on Tuesday morning, I think, just outlining to us, not her father-in-law. So she also texted me yesterday as well, just to apologise, and asked if I could go via the to yourselves via the hearings administrator, which I had great pleasure in telling her we had already done that, and that she should relax and take time with her whānau. So she gave an indication she'd be able to give the hearings, the legal submissions by early next week. I'm a little bit concerned that might be a little bit rushed, but also mindful that we're speaking Tuesday and Wednesday, or scheduled to speak Tuesday and Wednesday. So and also with Christine, the potential for Mai to be moved to later in the hearing schedule as well. Just wanted to see what your thoughts were on that as well, and if you preferred that legal submissions were first. Or...
No, so just to update the other commissioners, Council Te Kotahitanga, Maya Wakaira, her father-in-law was recently passed away, and she was due to give us some legal submissions for this hearing. We had some dialogue late last evening by Christine that I suggested to Sarah and the team that we give my leave to present us legal submissions on both hearings 13 and 14 next week together, and also to give all the time she needs. And we've rescheduled some time on Wednesday afternoon, and if it's more suitable to have her then, just to fit in with her capabilities amongst the family responsibilities, that would be fine. And we're certainly very interested in her views and her legal submissions on both these topics. So we'll just work around and just fit in with her.
I wonder if we did reshuffle the schedule so that Maya was heard on Wednesday with the legal, and mindful that Commissioner Coffin is tied up on the Wednesday morning, but if yeah, we could provide those legal submissions as late as possible.
Yes, just working. We tend to get them the day before, and we normally ask legal counsel doing submissions to give us a reasonably fulsome discussion. So it's not so much of a pre-read, but just working with Christine, and we'll work out what's comfortable.
I forwarded on your email to Julie as well.
Okay, great. Thank you.
Between us.
Hey, Stephen, just for my benefit, because my screen is not large on my laptop, I can hardly see who's. I think I can make out Sarah because I know she was just talking. So I've but our other two submitters have got masks on, and I can't quite see who it is. If they wouldn't mind introducing themselves, it would be.
Yeah, well, I think if that was the only matter that we needed to cover off, then we can introduce and go from there if that's okay. Oh well, tēnā tātou. Nice to see everyone, and thank you for allowing us to present in person. Liana, she can introduce herself, but Liana and I had a discussion yesterday around if we had the opportunity to present in person, we thought that it would be more beneficial. And also with Maria as well from Te Kahului. So anyway, yes, and thank you for your patience, and thank you for all of your help to the hearings administrators as well, getting all of this evidence. So pretty big kaupapa for us that you know, supposed to be a really quiet time of year, but obviously the busiest time of year for everyone. Anyway, thank you again for that. And for those of you that don't know me, I'm Sarah Mako, one of the policy advisors at Te Kotai Tango o Te Aotearoa. So we also have Adam Wild, who's a heritage architect on the screen as well, so he can introduce himself. He could potentially tell us about the artifact in the back of his video as well. But anyway, we'll go to Adam and then we'll go to Liana.
Yes, welcome Adam.
Thank you. Good afternoon, everyone. Kia ora. Picking up Commissioner Coffin's comments at the end of the last speaker, I wonder if I could just go straight to questions. But assuming that that's not the case, I might just quickly, on an assumption that my evidence has been read already, just take you through some of the highlights of the points that I have raised in that statement.
Yes, I think we're just doing introductions at the moment.
Okay.
And I'm not sure whether Sarah would like you to come after her evidence, but we'll just do the introductions first, and then Sarah can do her MC role from there and let you know when you're on.
Very good. So my name's Adam Wild. I'm a conservation architect and a registered architect. I am a director of a practice based in Auckland, but we operate around the country called Archifact, Architecture and Conservation.
Yes.
I've been engaged by Te Kohitanga to provide them with some expert evidence on heritage matters.
Thank you very much. Welcome.
Thank you.
And did you want to explain the tongue in the back of your room that Sarah mentioned?
There's many tonga in the back of this room, not just me. It's really this point here, the red jacket. I was explaining it to Sarah and the team just before we joined you. it's a piece of important New Zealand taonga that was given to me by the University of Cambridge because they didn't want it. They didn't see value in it. It happens to be the first jacket worn by the first New Zealander to the top of Mount Erebus. And I think it speaks a little bit to some of the comments that between Sarah and I, will traverse with you this afternoon in terms of how we perceive heritage and the various threads that bound together make for a better story.
Thank you. Thank you for that introduction.
Tēnā koutou, ko taranaki te maunga, ko te Aotearoa me taranaki ngā iwi, ko puke tapu me ngā te moe ahu ngā patou, ko muru rau patou, me para apuka ngā marae, ko te ana koutou tōku ingoa. Ko au te pauwhakarai o te kotahitanga o te Aotearoa. Hello everyone, my name is Liana Potu and I am the chairperson of Te Kotahitanga o Te Aotearoa, which is our post-settlement government.
Thank you, Liana.
Thanks for having us.
Yes. I think, look, we're doing our best with the mask. So the rules are, which we're pretty good at it, haven't we?
We have been all very good at it.
I'm always very conscious when I don't have it on and someone else is speaking, but yes, we'll just do our best with the masks.
Yeah.
Yes.
And so Maria's come to sit with us as well. So Maria, kia ora, or Maria Hokora Tokurua. And Maria Reda, I'm the planner for Te Kahua Taranaki Iwi, and I'll be presenting after Te Kotahitanga Dunedin. Moral support. Yeah. And so I'm not lonely later. Kia ora. So what we were thinking with Maria and I in particular is that our evidence, majority of our evidence is obviously very similar. So if you wanted to question us both at the same time, not in an official hot tubbing, but potentially we would be happy to do that if that does suit. In this, to start us off anyway, Adam's going to just speak to his evidence as well. So we'll start with Adam and then to Liana and to myself.
Thank you. Adam.
Kia ora. So I might just start at paragraph 16 of my evidence. I have introduced myself. And just I'll just briefly go through this statement, highlighting what I think are key points in terms of my evidence on behalf of Kotahitanga. And at 16, I just wanted to raise the point again that the listing, the inclusion of the east wing of the Barrett Street Hospital Nurses Home, which is currently recognised in the ODP, is not disputed in the proposed district plan. But we'll speak more on that briefly shortly. I do note at paragraph 17 that I would like to see greater clarity around what the values that it is being recognised for are, and Sarah will speak to that as well as Mr. McCurdy on an archaeological front, if he's here. So again, as I said in my introduction to myself, there are a series of strands in historic heritage management that I think this venue gives us a good opportunity to raise, to join the dots really. It's not a binary exercise in terms of heritage management. I think importantly, and I raised that point at paragraph 18 in terms of some of the values that the district plan has used and applied and through the section 32 process and recognised in the section 42A report in terms of intangible values. As much as we might be recognising the inclusion of a building, there are other values that lend it value and distinctiveness and therefore benefit to the public. I note at paragraph 19 that Heritage New Zealand has not recognised the building nor the site as an archaeological site. In terms of the proposed district plan and its coverage over heritage buildings and items, I make the point through paragraph 20 and when we turn to rule R2, that it would be helpful to understand a wider range of criteria than necessarily those just applied in this instance. And I think most importantly, what's lacking at the moment is a definition and clarity around an extent of place that's intrinsically associated with the object. We tend in heritage management to talk about places, not about objects. That's an opportunity to engage in that wider narrative, which Te Atiawa particularly are interested in this context, in terms of significance and value. And so I would like to see, as I've discussed in my evidence, some further concentration on a definition of the extent of the context or the site associated with the building. You will have read my commentary on general support for the rules from 1 to 9 in terms of their activity status and where the council is proposing them to stand. And I tend to agree with council, and we've worked closely with Te Atiawa to talk around what the implications of that are. And I think we've reached a really constructive point of agreement, which Sarah will speak more to. That includes activity status of development within the context of a heritage place. So again, that definition that I was suggesting before, aligned with the ICOMOS New Zealand Charter, would be a helpful further clarity for council to seek. I note too that in reinforcing that point, Heritage New Zealand, as much as they haven't recognised the site, have recognised that context is an important factor to consider. That's referenced at paragraph 26 of my statement. I do talk a little bit about the discretionary status of development in the heritage context, and I believe that's an appropriate place to land in the proposed district plan in this case, on two grounds. One is that council don't distinguish a hierarchy of places on their list. They're either listed or they're not listed. That follows many different territorial authorities around the country, Wellington, for example. And so the discretionary activity status aligns commonly with many of the other territorial authorities around the country. It seems to me a system that is working, and some clarity perhaps around the criteria that we might consider in terms of that discretionary activity would be helpful. And similarly, under Rule 9, the non-complying activity status for demolition and removal. And I spend a little bit of time through paragraph 28 discussing the risks of a blanket control when in heritage management, each place is taken on its merits on a case-by-case basis. So you may find that there's variation in the way you assess a place, that a blanket non-complying control may frustrate in terms of a wider understanding of what those values are. In the end, however, I've settled on a non-complying activity status for demolition to be generally okay. It still gives scope for the two sides of the ledger. It doesn't prohibit demolition, and therefore dangerous and unsanitary buildings could be reasonably demolished. But it also means that there's an opportunity to consider and weight those competing factors of cost and condition. Generally speaking, that's where I wanted to go in terms of my essential elements. I did want to just briefly touch on the Section 42A report and overlap again these various threads which I'm trying to bind together, where I both agree with the Section 42A report, this is in paragraph 31, and the Heritage New Zealand submissions around what relocation means in terms of those earlier rules. And I've concluded that I agree with the Section 42A report and Heritage New Zealand that the settings or extents of heritage buildings and items should be mapped, again, seeking that further and greater clarity. At paragraph 34, again referencing the Section 42A report, there's a brief discussion about the heritage character areas. I note that while a number have been promoted, the proposed plan only focuses on the central area, character area. I do make a note though, and I've spent, I feel, too much of my professional career in the Environment Court and venues like this, trying to be very clear about a distinction between special character, which I believe is an amenity matter, Section 7C issue under the RMA, and historic heritage as a matter of national importance and the protection that's afforded under Part 2.6F. So again, just a word from my experience that there is some caution to be had in how you determine the special character area of the central area and then those other promoted ones as the council works its way through listing those. And then finally, and in my conclusions, I talk a little bit about conservation practice. I felt that it's important for you as commissioners in considering the overall objectives of what the plan is trying to achieve, that and in respect of my client, that my professional opinion is that we need to draw a slightly wider lens to better respect the combination of tangible and intangible values that make up places of distinctive value for the benefit of the greater public good. I'm happy to stop at that point and take any questions that the commissioners might have.
Thank you very much. We have an order, and that starts with Commissioner Coffin. Thank you.
Thanks, Stephen, and thank you, Mr. Wild. That's been really helpful, you just going through, because most of my questions was, well, I was going to start with, so what are you recommending in terms of particular changes to the policies and rules? And I think it was useful you going through the paragraphs and interpolating the matters that you thought were really important for us to consider. So that was helpful in that regard. And I just wondered if you'd be happy to interpolate a little bit more on the assessments. And I'm interested in this. I don't want to characterize it as separation, but the discrete differences between the values that you would associate with the object or the items, and in this case buildings, and the place, which is often described as the land. And it's been a long while since I've done assessments under the what was previous pieces of legislation for Historic Places Trust, but we were at that time, I remember us being very discreet around looking at it from different lenses and saying, if the buildings weren't here, would those values still apply? And where they did, still applied, it was just an exercise. The place is really important. Or if this building was elsewhere, would those heritage values still apply? And it was just a different way of making sure that the values were really attributed carefully to the building, the object, and to place, and then events, time, and people, and just being really clear about that, because that helped make decision makers or managers in the future really discerning about what types of values they're managing and for what reasons and how they can do them. So I just wondered if you had some further comments in that regard.
Oh, thank you. That's a really helpful question, because it speaks partly to the evolution of heritage management in New Zealand. And we've moved, fortunately, I think, a long way away from slavish restoration and fascination in the object, and to a much wider lens, as you say, that looks to capture both context and, through that wider lens, the intangible values, particularly that Te Ati Awa have expressed to me very clearly an interest in, and I think a personal meaning in understanding place, so that in some respects the physical body of the nurses' home building represents values that to them are uncomfortable, but the building, the object, sits on a land and in a context, a whenua, and in a context that is much richer and much wider, much more important to them. And for me as a practitioner today, it's about recognizing sometimes those competing values and trying to give them all context. And what I like about heritage management are in fact the layers. I've been working on building in Auckland old government house, which has, as a temporary building, it's now nearly 180 years old, not done a bad job, but it's fallen in and out of fashion and flavor ever since the day it was built, when it was described as a fake and a sham. But today it's one of the highest ranking and highest prized buildings in Auckland and in New Zealand. But I think, interestingly, if you draw into understanding the values of that building, you end up describing the land around it, the space in front, the lawn, which was what the people of Auckland actually fought for when the building was threatened with demolition, and indeed the trees that have become this incredible arboretum of early introduced trees, and a discovery of values of native trees. So there's a series of understandings there. I think to go to one of your final points too, Commissioner Coffin, and to allude back to that jacket behind me, I worked on the huts of Scott and Shackleton in the Antarctic, and they were all prefabricated buildings. Shackleton's hut, I've found exactly the same building as a equipment shed in a bowling green in England. The first Discovery hut that Scott built is an outback Australian kit set building. You change the context and they have a different meaning. So I think to put those things together, you can then speak strongly about what the values are, both physically and intangibly, in terms of a wider audience who are interested in the place. And I think that's my only real criticism of where the proposed plan has gone, is I think the assessment is a good place to start, but warrants wider work. And I think Te Ati Awa are offering a really useful lens to be embraced in that process.
My other question is more a clarification, and you've raised it a couple of times in your evidence, just around a defined extent of place. And I was just wondering if you could interpolate, probably for my benefit, just a little bit more about that, because I was raising a number of thoughts in my head. Is, one is about being very clear and certain about where do the values, where do those sit, and different values have different extents. Some might be specifically in the building materials themselves and the fabric of the building, and others might be spatially mapped on a two-dimensional map, aerial map, that you'd see and say, oh yeah, that's the extent of the site. So I just wondered if you could interpolate for me just a little bit what you were meaning by extent of place.
So extent of place, in my reading of it, is particular to each instance. If we look at the Barrett Street former nurses' home, it sits within a wider institutional complex of the former hospital site, and that's perhaps reinforced or bookended by the other listed item on the site, which is the gates at the bottom of the hill. Yes. But it also has this cultural underlying significance in terms of place and extent with the PAR site, and some archaeology that has been recognised. And therefore, I think, and layered to that too, is planting and a designed landscape. So each of these things give opportunity to define an extent that gives reference to the built element. And I think it's a slightly more discerning exercise than where the Section 42A report suggests that we might look at sort of radiating degrees of sensitivity, 5 meters, 10 meters, or perhaps the legal boundary, which is commonly an Auckland Council default position. I think we can get instances where we overlay a bit more than what maybe we currently legally own. That's not to say we're claiming it, but it's a context to understand.
Interesting. I think we could have quite an interesting offline discussion about this area, which I'm quite interested in, but we might just leave it there because those are my questions thus far. I suppose I'm making an assumption of more discerning articulation of the spatial extent of the values would then inform what might be protected or the various degrees of protection or where you focus that protection. And it doesn't have to necessarily be a circular heat map.
No, that's right. And it also not just protecting, but also in guiding appropriate subdivision use and development, that Section 6F matter that the RMA is interested in.
I suppose I'm thinking aloud a little bit. That probably means quite a sophisticated way of doing assessment, and then a rules framework which would be able to provide for those, which is not what I currently see. This is quite complicated, but I wouldn't necessarily call it sophisticated. Yeah,
look, I think that's a fair comment, and I'm loath to put more pressure on territorial authorities. I think the RMA gave them a bit of a hospital pass when it moved heritage management from Historic Places Trust to territorial authorities. But at the same time, I think it's really important that local people have the first line of control in terms of recognizing and understanding, and from that protecting historic heritage.
Okay, thank you. Thank you. Over to you, David.
Thanks, Antoine. Mr. Wild, just before I asked you some questions, I just want some clarification from the 42A author, if that's okay, Stephen.
Yes, go ahead.
Yes. So Lauren, the status of partial demolition in your Section 42A report, is that now recommended to be a discretionary activity?
Yes, that's correct.
Yes, okay. And that's a new rule, isn't it?
Yes, and I've also proposed a definition for it as well, which you'll find at the bottom of the set of amendments.
Yes, but there's no definition for alterations or additions, is there?
Oh, yeah, there is actually.
Is there in relation to heritage?
Yes. If you hover over the
it's at the end, isn't it?
The two words on the rules, if you're in the actual e-plan.
Okay.
But I can read them out for you now if that helps.
No, it's just I didn't see them in the track change version of your 42A.
Oh, sorry, they're already defined in the PDP version, and so I haven't shown which words would be highlighted. It's hyperlinks in my amendments.
Yes,
but
okay.
Into the plan.
Right, and the what was the notified rule that related to both partial demolition and full demolition? What number was that?
We didn't have a rule for partial demolition. We just had the non-complying one.
And that was rule
9, I think, from memory.
Right.
That's right, rule 9.
Yes. Okay. Thank you. Thank you. And so partial demolition now is HH new, and full demolition is still HH9, except that it relates to just full demolition as opposed to anything else. In fact, it's called total demolition now, I think. Yeah. Okay. Sorry, Mr. Wild. How does the plan distinguish between partial and total demolition Is it by definition or some
Yes,
other
it
means?
is. Yes, so I've inserted that definition for partial demolition, and I've taken that from Heritage New Zealand's their Sustainable Management Guidance Series for district plans.
Yes.
And I thought I would get some evidence on that, but I haven't. It seems to have gone through unchallenged.
Okay, I may well be missing a page because
It's 24 of Appendix 1, David.
the 24. Yes, I have it. Thank you. And that's the definite that uses the term substantial, isn't it?
Yes.
Yes. And you might recall I had a question on relation to how that's measured and determined. Yes.
Question to me.
Which I was expecting you to come back to on your right of reply. So that's just recording that for my benefit. Okay, that's useful. Thank you for that, and thank you for your patience, Mr. Wild. Mr. Wild, are you giving evidence as a heritage architect or as a planner in these proceedings?
As a expert conservation architect.
Yes, because you cover some planning ground in your evidence, and I just wasn't sure whether you're expecting questions on that.
I'm happy to take whatever questions you've got, and if I feel I'm getting outside my expertise, I shall let you know.
Okay, well, I guess what I want to explore is the original relief sought by your client in terms of moving, opposing the non-complying activity status for demolition or removal, which was Rule 9, and replacing that with a restricted discretionary activity status. And it's clear to me in your evidence that you don't support that. And in fact, at the bottom of paragraph 28, you come to the conclusion that full demolition of a building should remain a non-complying activity. I wondered whether you'd given any consideration to an intermediary activity status, such as fully discretionary activity status for total demolition, aligned with a strong policy basis.
I would be happy to consider that. As I said in an earlier answer to Commissioner Coffin, the New Plymouth District Council proposed plan doesn't distinguish in its heritage list between status of buildings. They're either on the list or they're not on the list. And my reticence in adopting more finer grained hierarchies was because it doesn't reflect the lack of hierarchy in the list. Either a place is listed or it's not. So it seemed to me an easier way of managing the process, both from a practitioner's point of view, from a building owner's point of view, and from a council perspective, to manage it in a single strategy.
But is that what the proposal that's in front of us does? It has a split strategy between restricted discretionary for some activities like removal of certain listed activities, discretionary activity status for partial removal, which relies on an interpretation of what substantial means, and then non-complying activity status for total removal with and you'll understand that the gateway test of a non-complying activity, either the effects have to be minor or that not contrary to the policies and objectives. And I don't think anyone could argue that the removal of heritage fabric is going to result in minor effects. So all focus will be on the policy, and the policy that's in front of us at the moment makes recognition of certain circumstances where total demolition might be appropriate, such as health and safety risks, those sort of things. But aside from that, it doesn't really lend policy support for any other reason, whatever that may be, other than what might be caught up in the public benefit criterion. And so I was interested when you said, Mr. Wild, that non-complying activity is not a prohibition. for total removal. But I just suggest to you that unless the policy anticipates the reasons for the demolition, and if the activity doesn't encompass those reasons, given the structure of the 104 test, effects are always going to be more than minor, and there's no policy basis for the removal, surely that's a quasi prohibition for total removal. And wouldn't it be more honest for the plan to actually say that?
I'm not sure I could comment on the last comment, and I'm not sure I can comment too helpfully in terms of the fundamental part of the question, because it is a planning one.
Yes.
In my experience, it is a rare moment indeed when a council chooses to prohibit an activity.
Yes.
In Auckland, in the heritage context, it is done through the unitary plan only with regard to the demolition of category A places. And again, I'm making the point that the proposed plan here doesn't distinguish between types of heritage, it's just heritage.
Yes, I understand.
And therefore it would require through policy much more, I think, refined analysis of those factors that are affecting a place that generates a desire for its demolition, being much more centered around health and safety, perhaps closely aligned to the dangerous and sanitary building provisions that the council might have.
Yes, I didn't want to get sidetracked on prohibited. I was more interested in what non-complying activity means for proposals that don't satisfy the dangerous health and safety aspects. And to me, it just seems that there might be a policy gap in catering for those, so that any application that comes before the council is largely doomed because of the way that Section 104 is structured.
It's a really interesting point.
It's an interesting point that I've come across on several resource consent applications, some which you may have been involved in, some that you may not have been, but yeah, sorry.
Yeah, indeed, and I think what I've experienced in practice in various parts of the country with respect to demolition is drivers that are particular to each case, and that it's difficult to use that blanket provision without being very discerning. And that's why I think the non-complying activity status provides a very high bar to challenge a determination for demolition in the heritage context, and I think that's appropriate.
Yes, but I'm sure if that bar is so high that it doesn't contemplate demolitions other than for the health and safety and structural integrity type reasons that were discussed, is that setting the bar too high?
It hasn't been in my experience. It may be a question to council itself in terms of their administration of the provisions, because certainly in my experience, there's been a lot of tension in the way those policy objectives have been administered in the field, and that's where we've often ended up sitting across the table in a hearing trying to explain to an independent party the pros and cons of a particular approach.
Sure. One of the things that as a decision-making panel we need to consider is what is the most effective and efficient way of landing these provisions. And so we have to have some regard to alternative methods. One of those that's been suggested by your client was restricted discretionary. You clearly don't support that. If we go up the chain a little bit, a fully discretionary activity would be one that could be declined.
Yes.
So it's no different from a non-complying activity in that sense. But it doesn't suffer the restrictions of Section 104. But if the policy was crafted in the right way, it could enable meritorious applications to be approved and ones that are clearly not appropriate to be declined without the need for the non-complying activity, which might second guess the outcomes otherwise. Do you see the argument that I'm suggesting there?
Yes, I do. And I think it's got strong merit to put back to council for them to consider. I wouldn't be against it in a management sense from my perspective as a practitioner. But yeah, it's whether the council feels it's capable of the nuances that would be required.
Sure. It would certainly put a lot of focus on policy 7.
Yes.
As would the retention of non-complying activity status, perhaps even more so. Policy 7 will become absolutely critical under a non-complying scenario. And just in those terms, I was looking at some of the matters of discretion that your client's submission had originally outlined. And there were 3. The first one was the safety, risk and property and the state of disrepair. Second one was the cost of remediating the risk was prohibitive. Now, like me, you've probably seen this criterion in a number of district plans around it doesn't seem to be representative in this plan. And I just wondered, assuming I'm right, and the officers will correct me if I'm wrong, but the reasonableness of the costs of restoring a building as opposed to demolishing it don't seem to be part of the equation here. And I just wondered if you've got any comment on that.
Yes, I've seen probably too many times now the argument over the cost of conservation being the key Achilles heel in the future of a heritage building. I'm often minded of the High Court's decision in Harcourt, where it determined that to spend $12 million, they might make 20. And I think that's sort of about what happened. In a heritage context, I think we have to be, my opinion is we need to be slightly more mindful of more than just the dollar cost. Yes. And that there is, I think, a point, again, the High Court made in considering the legal appeals on Harcourt, that the public are effectively the beneficiaries of historic heritage as much as more often than not it sits within private hands.
Sure.
And so another balance that the council should be considering is incentives to support those charged with that responsibility, that guardianship.
Yes, I understand that. And I guess all I was suggesting to you is not necessarily the answer to whether it should be a determining factor, but whether it should be part of the consideration. And then how much weight's put on it by a decision maker then will be applied accordingly. But it just seems to me, Mr. Wild, that it doesn't seem to be part of the equation at all at this, and any of the policies that I've seen. And I'm just suggesting to you, maybe it should be there for consideration.
Yeah, and I would certainly take no exception to it being part of the consideration, but I would counsel that it is a relative measure.
Sure.
And you need to be minded of that.
Yeah, it's either it's. I guess the question is, should it be in the tent or not? And at the moment, it doesn't appear to be. But as I said, I may have misread the rule. Okay, I think that's all. Just let me check the rest of my. Oh, so I had a very minor question, and that was about one of the early points that you made about adding in context to a listing, and you used the word definition, and I wondered whether you meant definition or you were saying that should be some additional notation on listings. Could you just elaborate there? It was one of the initial points that you made in your verbal presentation today.
Yeah. I think paragraph 22 of my statement refers to a couple of quotes from the ECOMOS Charter and from two different parts of the ECOMOS Charter talking about context and setting.
Yes.
And whether that's definition enough, I think it's for want of a better place, it's a very good place to start in terms of considering that context.
Okay, so this would be a provision that would apply across the plan, across all listed sites, not just this particular building that we've been talking about.
Correct. And I believe that's where Heritage New Zealand submissions were also going.
Okay, that's good. Thank you for that clarification, and thanks for those answers, which were from a sort of a planning approach. I appreciate your candid responses.
You're very welcome.
Thank you, Stephen.
Yeah, thank you very much, Mr. Wild. I think you've been given a reasonable going over by the other two commissioners.
We went lightly. We went very lightly.
Yeah.
You should see when we really get going.
Yeah. Yeah. No, I think it does reflect your careful and considerate evidence that you've raised with us. You're obviously highly experienced in these processes, and I think the combination of your expertise working in the wider team of your client does add a lot of value. So we really appreciate your involvement and your advice to us. I did have one question following on from David's last question. It was about the setting. I suppose the way I've thought about the setting, I thought you were talking about how the setting of a heritage building was described in its description, I suppose, rather than some more general requirement to talk about setting, because the places are set in the schedule. They do have an assessment associated with them. And were you more thinking about providing a more fulsome description of the overall setting in the description of the place as referenced in the plan? Because you said right at the end of your evidence, the only key issue you have with the Section 42A approach is the assessment warrants a wider lens. And to my understanding, each of these buildings has an assessment. So were you referring to some upgrades needed to the assessments of these buildings
Yes.
in the listing?
I think in terms of the assessments done to date, I think it's that they're still a little shallow on their consideration beyond the building as an object. And I think it's important that we look at that setting. I'm mindful of words used in the ECOMOS Charter definition that I've included in my evidence at the top of page 7, midway through my paragraph 22, where it says setting means the area around and or adjacent to a place of cultural heritage value that is integral to its function, meaning and relationships. And I think it's that integrity that we're looking for.
Okay, so how would that wider lens be applied in our circumstance where we have a schedule of historic buildings and other sites? We have an assessment that underpins those. Could we go back far enough to say, well, look, we need to change some of the assessments to create a wider lens, because those aren't a policy or a rule or anything like that. They're sort of an underpinning justification for the listing.
Yeah, no, look, that's a good point. And no, I don't think we need to go backwards. And I think the assessments done to date are a perfectly reasonable starting point. I think there's some refinement that should be done, and part of that comes from the submissions of Te Koutaki Hangatanga in terms of their relationship with council and this binding of various threads, as I've been talking about through this submission, that to understand the values of a heritage place is more than just understanding the bricks and mortar of the building, but both the tangible and intangible. So context is part of that wider tangible sphere that we need to consider. It is addressed in terms of the assessment criteria in the district plan at the moment, but I think the assessments that have been undertaken are still a little bit light on that wider context, because it doesn't draw a line to, you know, where does the place stop being important?
Yes, yes. So I think my own practice in Taranaki around resource consents, that linkage is getting better through practice of the council and the way that hearings are heard and people coming to talk to decision makers with that wider lens. So it's just I'm interested in how the plan might be able to make that broader connection as we go forward, which is a topic which we talk about at most hearings with the team here. So,
well,
yes.
to be fair on the district plan, I think the criteria that it's promoting in terms of how we assess a place of heritage value are appropriate.
Yes.
We can refine it to include some more threads, but I think the assessments themselves, and it's partly a practice issue, need to be tested and challenged a little bit harder, just to make sure that they're complete enough for council to make a robust determination around.
Yes, all right. So this is more of a future practice than when perhaps other buildings are looked at in the future.
Yeah.
Yes. Okay. Thank you very much for your assistance, Mr. Wild.
Very welcome.
All right, Sarah. I'm comfortable myself. If you'd like to, we're going to hear from Lana first, aren't we?
Yeah.
Yes. Okay. Sure. It's
as I said in my introductions, my name is Liana Potu and I'm the chairperson of Te Kotahitanga o Te Atiawa. Now, I received some instructions from my lawyer. I don't know about a lawyer instructing another lawyer on how to give evidence, but she encouraged me to read out as much of my statement as I could. I'm going to paraphrase some of it, but I think there are some important contexts that I think it's important for everyone to hear.
Yes.
So I'll do that. So as I said, I'm chair of Te Kotahitanga o Te Atiawa, and that entity was established as the post-settlement governance entity to manage treaty settlement assets that came across to us. I've held that role since the establishment of our entity in 2014, and I'm also director on our commercial subsidiary, which undertakes our property developments on behalf of our iwi. And that's a role that I've held since that entity was established in 2016. My qualifications are set out in my statement of evidence. Just to be clear, I'm not a planner, and I'm not all over this. This is not, that's not my lane, but I guess what my evidence seeks to do is provide a bit of broader context in terms of how we practically as an iwi on the other side of treaty settlements have to engage in developing properties, acquiring properties, and how we ourselves, I guess how we work about manifesting the aspirations of our people on lands that were taken from us, but we now have to purchase and acquire to re-establish ourselves in our lohi. So I'll give some of that context and talk about our aspirations, and then there are a couple of properties that I wanted to use to highlight in terms of properties that are available to us through our settlement, our treaty settlement, and how we might go about navigating some of the issues within that. So as a bit of background, Te Kotahitanga, as I said, was established in 2014. We signed a deed of settlement with the Crown in 2014, and the deed of settlement essentially sets out the redress package that's provided from the Crown to our iwi as a settlement of historical grievances. So there are a board of 7 trustees on that entity, and obviously I'm one of those. In our deed of settlement, we also have a Settlement Claims Act 2016, which enables the provisions in our deed of settlement, essentially, and it gives effect to them. Our commercial company, our limited partnership, it's a limited partnership, so it's between Kotahitanga, our parent entity, and a management limited company. And that's responsible for commercial investment and development of our Tiatiawa Treaty Settlement assets. So there's a board of 5 directors on that, of which I am one. Deferred selection properties. So one of the financial and commercial redress components of the deed of settlement is what's known as deferred selection properties, or DSPs. And these are properties where Kotahitanga, in our case, has the right to elect to purchase within a specific time frame and under the detail prescribed in our deed of settlement. So we have a total of 51 of those properties listed in our Tiatiawa deed of settlement. So the process for acquiring those is set out in quite some detail in terms of notification, valuation process, how we go about making the final decision to acquire those properties is set out in quite a lot of detail in our deed of settlement. But essentially what happens with DSPs, DSP properties are properties which were previously owned by the Crown and are no longer required by the Crown for public purposes. So at some point, these properties were deemed to be not required by the agency that held them at the time, and then they go through a process of being offered up to other Crown agencies to determine whether they could use them for a public purpose. At that point, if no other Crown agency has an interest in the properties, then they're placed into what's called a land bank. And then the land bank is set aside, the land's set aside for use in treaty settlements. And so essentially that's how our DSP, properties came about and how we manage and deal with them. So if I that's an overview of our entity and our settlement and how we came about. But I want to talk a little bit about muru me te raupatu, which is translated essentially as the plundering and confiscation of our land. So when the Waitangi Tribunal reported its findings in regards to the historical Treaty Waitangi breaches by the Crown and Taranaki, the Tribunal stated there may be no others where as many treaty breaches had equivalent force and effect over a comparable time. The Tribunal went on to state, we see the claims as standing on 2 major foundations, land deprivation and disempowerment, with the latter being the main. By disempowerment, we mean the denigration and destruction of Māori autonomy or self-government. So Tiatiawa, along with our whanaunga iwi and Taranaki, because we're not the only one that suffered these injustices, but we suffered brutally at the hands of the Crown. And I don't mix my words when I say brutally, because it was brutal for our people. And our entire Tiatiawa rohe was confiscated under the New Zealand Settlements Act 1863. So as a result of Crown actions, Taranaki Māori were dispossessed of their land, leadership, means of livelihood, personal freedom, social structure and values. The losses were physical, cultural and spiritual. So although Tiatiawa has been through a treaty settlement process, I guess the ongoing effects of confiscation and that history didn't stop or didn't magically stop as soon as we signed a deed of settlement with the Crown. And the barriers to regaining those things that were lost through those historical actions are constant and unwavering for us to this day. Tiatiawa were effectively landless in our own rohe at the time of signing our deed of settlement. And it's only now that we are working towards reclaiming some of that land for the collective benefit of our people. So while individuals might have owned land, we owned no land as a collective. However, in a cruel twist, we are now required to use our settlement monies provided as compensation from the Crown for the confiscation of our lands to now purchase those lands from the Crown to be able to exercise rights on land within our own rohe again. While I understand that this forum is not the one to make determinations on those historical events, I think it's a really important context. It's really important context when considering the impacts of decisions on the proposed district plan in respect of historic heritage, including heritage buildings, archaeological sites and notable trees. Recognising the ongoing impacts of Muru me te Raupatu and colonisation on Te Atiawa Uri will be an important factor in those considerations. So one of the key aspirations of Te Atiawa is to re-establish our identity and presence on our ancestral lands. The process of Muru me te Raupatu was focused on the assimilation of our people and erasing the existence of anything Te Atiawa. For too long, non-Māori heritage sites of significance have taken precedent over our Te Atiawa heritage and sites of significance. The balance needs to be restored. Te Atiawa seeks the ability to reimagine, recreate and maximise the opportunities available to us via our deed of settlement, and to not be encumbered by sites which are a legacy of the past. Te Atiawa has the ability and resources to reimagine and recreate some key cultural sites within our tribal rohe and within the New Plymouth district, but we need to be enabled and empowered to do so. It's only been in the last 12 to 18 months that Te Atiawa has had the opportunity to really consider how applying our own cultural expression might manifest itself in subdivision and urban design as a result of our settlement and the emergence of some willing developers in the community. And this is a seismic shift from only ever being able to consider what we didn't want to happen on the site, as was the case under the operative district plan. Te Atiawa is continuing to develop its design approach with creatives within our own iwi, and our expectation is that this will continue to be the planning conversation held with respect to our sites under the rules of the proposed district plan. So now if I take you to a couple of these examples, so Otu Maikuku. Otu Maikuku, the former Barrett Street Hospital site, is a very clear example of where the balance of non-Māori heritage and Māori heritage has gone askew. It is also a very clear example of an encumbered site which is a constant slap in the face, reminder of what was lost and the ongoing legacy of that loss. By way of brief background, Otu Maikuku was a pā site located in a strategic position with views across the land, now city, and out to the ocean. It was a thriving settlement with a great vantage point. When European settlement began in the 1840s, the site was designated as a native reserve. Following this designation, the New Zealand Settlements Act 1863 came in, which passed the confiscating of the land. Many Te Atiawa and other Taranaki, Kainga and pā were often destroyed to make way for stockades, forts, military camps and blockhouses. Otu Maikuku was no different. Eventually, the land at Otu Maikuku was acquired by the Crown to establish it as a hospital. I guess if I add there, if you look at the Taranaki landscape and the district landscape, wherever you have the listing of a stockade, a blockhouse, a fort, you can guarantee that it's on top of a pā site. In every single instance, I am not aware of any blockhouses or forts that are just established on free land. That, you know, and I guess that's the point, is often those sites are recognised, but the pā sites upon which they were built and established are not recognised. So despite the formal official name change to Otu Maikuku through our Te Atiawa deed of settlement, this name is not acknowledged or used by anyone other than Te Atiawa. And the protection and acknowledgement of the Māori heritage of this site has never been advocated for by anyone other than Te Atiawa. This property is in the process of being purchased by Te Atiawa through the DSP process, with the aspiration of reimagining and reinventing the site for the future. I talk a lot about reimagining and reinventing because our settlements are not just or fair, but what settlements do is that they allow you an opportunity to move forward and create a different type of future for our people. And so I use imagining and reinventing a lot because that's the absolute aspiration, is that we don't want to be constantly reminded of the past and the grievances that affect our people. We want to look forward in terms of where we go from here. The property, I guess the property and the aspiration for us in reinventing that site is hindered by the current heritage designation of the eastern wing of the former Barrett Street Nurses Home at Otumaikuku, the hospital gates and the brick wall, as well as the proposed scheduling of an unnamed blockhouse under the proposed district plan. Not only does the retention of the nurses' home, gate and brick wall significantly hinder the development of that site, it also places a heavy burden on Te Atiawa to resource the removal of asbestos, restoration and ongoing maintenance of those structures, which remind us and continue to represent the confiscation of land and the stamping out of the Māori heritage of that site. The proposed scheduling of the unnamed blockhouse at Otumaikuku only stands to further acknowledge the non-Māori heritage of the site, with complete disregard for the Māori heritage and the aspirations of Te Atiawa for a site of cultural significance to us. And if we look at Otumaikuku and where the nurses' home is located, it's on the highest point of that property. It's where the PA site was, because our people didn't establish PA down the bottom in the gully where they can't see their enemies coming. They didn't establish them down the bottom where there are no views. They didn't, they were really deliberate about where they established their PA site. So where the nurses' home is at the most prominent part of that site. It's at the entrance. So any development going forward, every time you enter that site, you're reminded that actually it's not really a Te Atiawa site, because we're here recognising this heritage that's not ours and that we were landed with, as opposed to entering a site and going, this is a Te Atiawa site, a Te Atiawa whenua. So our Te Atiawa vision for Otumaikuku is to establish a place that will once again be open, accessible, will provide housing, public open spaces and community immunity for all. Achieving all of this while celebrating and acknowledging the varied history of the site in a modern context will be key to its future success. Recognising the impacts of only non-Māori or Western values determining the significance of historic heritage, including heritage buildings under the PDP, is imperative, as it is recognising the impacts of district plan overlays in achieving the aspirations for Te Atiawa Uri One Treaty Settlement land. I guess I refer, and I really like the strategic objective of the proposed plan, which, talks about tangata whenua being able to protect, develop and use Māori land and treaty settlement land in a way which is consistent with their cultural and traditions and their social, cultural and economic aspirations. I can't think of a better way of articulating a strategic direction and a plan for us. Yet there are many things that are highlighted at Otumaikuku that actually don't help us achieve that strategic direction of the plan. Turning now to my second example of Pukekura, the parade. So the parade is located just up the road from the council chambers at 99 Liara Street. It's the second example property which supports our submissions. So this is the name that Ngāti Te Whiti, one of our hapu here, and Te Kotahitanga have given to our proposed townhouse development at that centrally located, residentially zoned property. This is another example of where the non-Māori heritage and Māori heritage is askew. Notwithstanding this, we consider we have attempted to reflect both our Māori history and the non-Māori history of the site, beginning with the name of the proposed development. So Parapara was the name originally given to that whenua, a reserve area most likely used for the processing of organic waste and or reference to the Parapara tree. Following settlement, this is European settlement, the area was known as Poverty Flats, St. Michael's Square and the Parade Ground. So the site was literally used by colonial troops to parade prior to engaging in warfare with our people. The site was eventually acquired for education purposes and used for those purposes until being placed into the land bank. The property contains the Heritage New Zealand Pouhere Taonga listed Taranaki Education Board offices, or former offices, and a number of the existing buildings on site utilised for education are identified in the ODP but have no rules associated to their protection. Notable puriri and Puretakawa trees line the Liata and Lemon Street frontages. I mean, one of the difficulties that we have as an entity coming in to purchase these properties that have Heritage New Zealand Pouhere Taonga listings is that I'm confident that there was very limited or non-existent engagement with our people in terms of determining the significance of that site. And I think about a recent example at Rahiri Cottage, just on the outskirts of the national park. To be frank, an email is not engagement. An email to our iwi office is not engagement. And so I have little confidence that those making a decision about placing that list, on a heritage listing, that they have been able to take into account the cultural heritage of that site. And how they I don't know how they could demonstrate that they've done so, yet it's still listed. And when we look at Otumaikuku, the former education board offices, all of those are the same. So all of these decisions are past decisions under previous regimes, I get that, but having good engagement to fully understand the cultural heritage values is important, because those sites don't always have physical heritage components to it. Māori cultural heritage is not necessarily about built heritage or physical, tangible taonga. They are cultural, they are spiritual. And I also talk about we have inherent responsibilities by the fact that we are descended from those lands to treat them with respect and look after them. And those are things that an archaeologist is not going to find. And so if our people aren't engaged in the process and there aren't lots of triggers for our people to be engaged properly in the processes, we end up with situations like Pukekura and Otumaikuku, where we're lumped with these listings that we had no say in at the beginning, and we're trying to unravel and manage them now. So it is our intention to retain the trees in our proposed development at Pukekura, noting that they could still cause issues for future residents in terms of maintenance and the acceptable levels of amenity being achieved within the development. I understand that the project archaeologist for the proposal identified 3 key overlapping heritage layers, with the historical occupation and activities on the site by Māori at the deepest layer and not visible. I guess that just goes to my point about these overlays are continuously recognising the non-Māori heritage because they're the most visible. And we need to find ways to address that. Again, it is the aspiration of Te Atiawa to reimagine and recreate a site within our tribal rohe that celebrates and acknowledges the layers of history, but to also enable Te Atiawa to re-establish our identity and presence on our ancestral lands. Again, recognising the impacts of only non-Māori or Western values determining the significance of historic heritage is imperative. I think I'll just close there and conclude there by stating that I talked a lot about the slap in the face of the nurses' home, and that's our constant experience, is that when there's no acknowledgement or recognition of our Māori cultural heritage associated with a site, what we see is something that represents confiscation, it represents plundering, it represents the destruction of past sites, it represents confiscation of land that we've never been able to use since. And then to have to acquire a site with treaty settlement monies that was supposed to be compensation, to then say you have to celebrate this iconic building that has heritage values, because that's more important than us being able to acquire that land and celebrate ourselves. And so I think that's the aspiration, that we want to be able to celebrate ourselves on our whenua without being forced to celebrate a symbol of hurt and grievance. So, kia ora tātou.
You're right. Thank you, Liana. Certainly well worth you reading out your statement. As I read it, quite a lot of interest the other day, but actually having you talk us through sets a lot of quality in the messaging. Thank you very much. Antoine, questions?
I was pondering whether questions were appropriate.
Happy to.
Because I tutai māku I mi ana ka koe I runga I ngā whakaro e kua puta mai I mui a tātou. Nō reire he honore kia mātou ki te whakarongo ki ngā kōrero a pāna ki ngā moimoi a ngā wawata o te iwi o Tiatiawa. Nō reire he mihi kawana, e mihi kawana, e mihi kawana. So I'd just like to acknowledge you sharing with us the vision, the dreams, the aspirations of Tiatiawa as you move mai te ao kōhatu o te muru o te whenua, te raupatu, ko tēnei ao te ao marama. Moving from those dark days of conflict and war and confiscation to the world of light and aspiration. So I'd just like to acknowledge in just a few words that very long transition. And ahakoa te ngenge, te hōhā hoki, o te kuwaretanga o tira o ngā kaupapa hei kaore e whakatira te iwi. Those things that are put in front of you that are barriers to the aspirations or the well-being of the people, that can be frustrating, can be laborious, acknowledging those things as well. There's questions coming, but I just wanted to just acknowledge you sharing your submission with us today. I suppose it's an interesting one because we're in a district plan process, and this is the process which establishes the policies, the objectives and the policies and the rules which are the framing for the way in which decisions will be made in the future. And certainly I think you brought to light, using two pertinent examples, the importance of getting a district plan framework right, because decision makers who may or may not be ourselves, there might be others who come along, including iwi representatives sitting in the chair, in the hot seat and going, does this framework facilitate a good decision being made? So also I'd just like to acknowledge the importance of getting things right, to setting things up for the future. And so having some examples was really important and helpful. And I suppose for us three, and Kit, who's not with us, just reminding us again the importance of our role in the decisions or the recommendations to the council on the district plan. I've got probably this one main question, and it's probably more of a process question. For the deferred settlement properties that are listed in the deed of settlement, and I'm assuming that a number of different agencies might manage them, but Lynn's probably manages a number of them.
All of them, yeah.
Are there formal encumbrances on the properties when you go through the process of purchase? Is it very clear about these are the encumbrances on the property? And I'm making an assumption it's taken as read there's a lack of tender love and care for many of these properties. These are the properties that many agencies didn't want. So often there's deferred maintenance, there's dilapidated buildings on them, come with all sorts of issues, contaminated sites, et cetera, et cetera. Is there like a quality assurance, like you receive a property in a reasonable state that you could actually develop it, or do you just get it warts and all?
Good question, Pātai Pai. Ngari whakamuki taku ato mihi ki au e mihi ana. So there's the process of valuation becomes really important. So the aspiration is that all of the DSP properties are returned to us unencumbered. That's the ultimate aspiration. And if the Crown has to remediate some of those things, end leases or other things, then they do so before it's transferred across to us under that process. But where there are encumbrances that can't be removed for whatever reason, then that's factored into the valuation process in terms of determining the valuation of a site. And contamination is exactly the same. So at Otumaikuku, one of the issues, and I think you've heard from Lynn's about their application, because the resource consent application, because that site was contaminated, and we had a commitment from the Minister of Treaty Negotiations at the time that we would receive a clean site or a clear site. So there's still some debate to be had about what exactly a clean site looks like. Yeah. And so we're still negotiating that. And so it's a bit of a process, but essentially the aspiration is that they come back unencumbered. Where they can't, then that's factored into the valuation process.
Okay. Thank you for that. I appreciate that. Just in terms of your recommendations, and I'm very much receiving the submissions and the evidence of Te Atiawa as a package. So there's your submission, there's the submission of our gentleman, Mr. I better get his name, Mr. Wild, Sarah Muckle's evidence, and others. And in terms of your recommendations, they don't necessarily go direct to the heart of what's in or isn't in the plan, so much as those are things that we should be considering. Those are things that we should reset. In terms of Te Atiawa's position, those are matters which we could consider as we're doing our deliberations and thinking about what is the right words that go in it. So I've made that assumption, but do Ms. Muckle's evidence and recommendations, do they go some way to providing for those matters which you've raised in your submission?
Yes, I think one of our aspirations is that it's not scheduled. If I look at Otumaikuku, right, yeah, that it's not a part of the schedule. It's not in the schedule because of all of the things that I've talked about, as well as the contamination, the safety of the building, te mea. But I guess the overarching point that we want to see is that actually there are some mechanisms included in the district plan that enable a more balanced approach and balanced view of Māori, I'm calling it Māori and non-Māori heritage, to be considered. Because when you look at criteria for assessment, in the main, it's about physical things, archaeological, remnants, all of those things. But
in terms of assessment criteria, it's not so clear that you should be considering the spiritual, cultural, I mean, I know it says cultural, but actually looking at intangible things. And if you can't see something, it doesn't mean that it's not as important as the seen heritage. And that's, in my view, what's missing, is that there's so much emphasis on the physical that actually that's where the balance goes out, right? Because if you look at Pukekura and you know, what was the archaeological work that was done at the parade, you know, the Māori layer was the deepest and you pretty much couldn't tell it was there. So it's really encouraging, and I don't know, I'm not the planner, and I know that Sarah's been doing a lot of work towards that, but it's really about how do we get the balance right? Because I'm not saying that Māori heritage should take absolute precedent over non-Māori heritage, but our experience is that the balance is not being achieved under the current regime, and that needs to change. And whether that's strengthening the criteria assessment, strengthening the engagement, you know, the triggers for engagement and what that engagement might look like, that would be an improvement, and that would help us get that balance back. Don't know if that's helpful.
Thank you very much for that. He mihi ka wana. I tukuna tū rākau kia koe, David.
No pressure. Good afternoon. I did have a question prepared, but I may come back to it, but I just wanted to pick up on your very last point about getting the balance right and using one of the two examples, the nurses' home that you used in your statement. What does getting the balance look like to you in respect to that property? Because I was very conscious of you referring to the strategic objectives and that you're a big fan of them, and the particular objective that you focused on was about allowing the aspirations of iwi and Hapu to be realised on treaty settlement land. But I'm also conscious that the council has a requirement under the RMA section 6F to protect historic heritage, which includes sites with cultural value, sites without cultural value, sites with architectural value, association, those sort of things, from inappropriate subdivision use and development. So there's a couple of tensions there, and I just wonder how they play out on a site like the nurses' home, and how you see that balance working. Because on one hand, I'm hearing a very strong plea for protection of cultural values, which are part of the historic heritage pool, but on the other hand, I'm hearing a plea for some leniency on the rules that might affect that historic heritage on that site, and that's a little bit confusing. So I just wonder what your response to that is.
Yeah, I mean, I think one of the difficulties for us having come through treaty settlement is that there are very few properties that we have an ability to exercise a right over. And so when I talk about us being landless at the point we signed settlement, what we're trying to do is re-establish our tribal identity in our tribal area of interest. And it seems to me, and I've worked in treaty settlement processes and negotiations for a long time, that these no longer required Crown land banked sites are often the ones that have heritage value, basically because they've been sitting there for so long and someone's had time to put an application in to preserve it, as opposed to the site down the road that went into private ownership and got subdivided. And so it is difficult. It's a difficult tension because these sites have been uncared for a long time, and then they turn up here, and it's only because, literally because, others down the road or in another suburb got in and subdivided before an application was able to go forward to protect a site. And so what I'm saying is that actually treaty settlement lands that are subject, and we're talking 51 properties, right, for us, and look, many of them have already been transacted. But for treaty settlement properties where there is a right for an iwi entity to exercise a right over a property through treaty settlement and through treaty settlement legislation, that might be a way of being lenient in that aspect, because what you're saying is that actually this is an opportunity for these iwi to re-establish themselves. Shouldn't they be able to re-establish themselves in a way that they want to re-establish themselves and re-identify themselves? And it doesn't mean, there could be, I'm just thinking out loud here, but there could be options for celebrating the nurses' home and celebrating the former Barrett Street Hospital without retaining that building. And it's an extensive building, and it's a, you know, and it's in the most prominent part of the past site. Like, are there other ways of doing it so that don't involve having to keep that particular structure in that particular place?
That's a very good question. It's always a good technique for the submitter to raise a question back to. So 10 out of 10 for that. But really, that's the nub of the issue, because you said at your paragraph 23 that the current heritage designation of the eastern wing of the nurses' home, as well as scheduling, become an obstacle to development of the site. And you go on in 24 and says it places a heavy burden to resource the removal of different things, including the building itself. So at the moment, I'm not seeing in the proposed plan a consenting pathway for the removal of the nurses' home because of its activity status and the policy framework that would be considered under that activity status. And I guess that's just a way of illustrating some of the conversations I've had over the last 2 days with different witnesses, including the 42A officer, the witness for Lynn's, Mr. Wild, and other matters about the activity status, the importance of getting policy right too. So I don't know if there's a question there for you other than acknowledgement of what you're saying in paragraphs 23 and 24. And these are things that Ms. Marco might want to pick up in a planning sense.
I mean, I'd agree. I think that there's, you know, we really have to look at creating pathways, because I mean, I'm not a planner again, but I understand that there are processes that we have to go through for different things. But what strikes me as somebody who's involved in this iwi space is that the pathways always feel harder for us, because we're always trying to remove non-Māori heritage, which sits on top of Māori heritage. And that pathway is always difficult. And I'm not aware of any example where there are people arguing for Māori heritage to be moved off non-Māori heritage. And that's the difficulty we're in, is that we are always the underdog. We are always the ones trying to have our heritage recognised. It's never flipped the other way. And
yes.
So there must be a way of creating a pathway that makes that more accessible to us and enables us to achieve our aspirations.
Yes, we did hear yesterday from 3 or 4 or 5 submitters opposed to proposed listings from other submitters, both in terms of notable trees and buildings. And I'm thinking particularly, I think it was Mr. and Mrs. Sharp who owned the dairy on Lemon Street, Elliott Street, is it? Yeah. Same issue for them, the impost of going through a consent process and no guarantee that it would be successful or favourable. So we're hearing it from both a a Maori cultural perspective and a European perspective. So I think the issue is a I think it's a common one in that sense. But Mr. Chair, that was all I had in terms of questions.
Thank you, David. I just wanted to establish from whoever can tell me just a couple of facts, I suppose. So we heard from Mr. Wild that the building we're talking to at the old nurses' home is not an item on the New Zealand Heritage List. That's not right?
Oh, it's not listed in heritage.
It's not listed in Heritage New Zealand. It's not one of these A, B or C category buildings.
They have category 1 and 2.
1 and 2, that's
and
right.
We have the A, B and C.
A, B. That's,
So, yeah,
it's never been listed.
Not one aware of.
It was in the ODP, this
Yes.
site?
Yes.
Okay. And from your criteria, it obviously meets the criteria to be listed.
Mhm.
Okay. In terms of Otu Mai Kuku, the PA, is that a SESM?
It is. It's listed as site 2647, I think, from memory.
Okay.
On schedule 3.
Okay. So I just hear Mr. Wild was saying it's not mentioned in Schedule 3, and I've just sort of gone back and forth, but
No,
it is.
that's not correct. It is mentioned on schedule 3.
All right, thank you.
Could I just mention something on the Otu Mai Kuku
Yes.
scheduling? So
Yes.
it might be worthwhile bringing it up on the screen.
Yes, I'd like to do that.
When you look at Otu Mai Kuku, it follows the part. So it. Oh, this is something I've presented for a long time. So the extent of Otu Mai Kuku Pa / blockhouse follows a blockhouse. It doesn't. It's not.
Yes.
I'm really interested about the blockhouse and what's scheduled. So if we could, is there a, what do we bring up to actually get our head around the extents? I'm interested in the overall.
I think we just have to go on to the same site, the PDP, and go on to that same site where you were before for Barrack Hospital.
Yeah. No, I don't want the street view. I want to.
Oh, yeah.
Yeah.
Whereabouts?
At the same address in Barrack Street.
Okay, okay. And through the district centre?
Yeah.
Oh, sorry.
188B, 2 Gordon Street.
On here?
Yeah.
Or you could go to 25 Barrett Street as well,
25.
which is the opposite. You submitted yesterday. So also Commissioner Dave's just on so in this situation, Georgina touched on the resource consent for the decontamination. So she is correct with Te Koteitanga with Te Koteitanga with Ngāti Te Whiti have been working with LINZ to resolve issues to get the resource consent moving forward. And this was an issue that Georgina and I spoke about it at length around LINZ believing that the extent of Otu Mai Kuku was restricted to the blockhouse extent. We came to an agreement in the end that the extent of the park is much greater than just the shed. If you zoom in more, you can see the actual extent of the blockhouse.
Okay, I'll just share it with you.
I'll just go one more trip.
Yeah.
And that's the extent of the blockhouse.
But the blockhouse is not there anymore.
No.
And neither is the building. The only building.
Yeah, no.
So the nurse's home is essentially the only building that's on the site. So the resource consent for the, I guess, describing it as the decontamination also involves the removal of non-heritage buildings that are still there.
Yes.
So there's only a couple, and there's also foundations of buildings that are still on the site.
Yes, concrete pans and foundations and things. So what the blockhouse, it's a really quite a small area, and the par, on the top of the par, obviously, because that was the best place to be in terms of highest point.
Well,
maybe.
that's what that's what's debatable, because that's heading down towards the gully, right?
Yes.
So the nurses' home is back up towards the.
Can we just blow out of it? Yeah.
No. So that's the extent of the Street Hospital. So the highest point is up here, so this area, which is where the nurses' home is.
Okay.
So that's actually a lower point down where the
blockhouse was.
So that's the heritage.
Okay.
But what the point is that the extent of Otumaikaku follows the extent of the blockhouse, as opposed to
the mapping
the
of the
entire
plan.
site.
Yes. So as we know, if there was a par there and people living there, it would be the extent of the living place, and the associations would be much poorer.
Yes.
Yes. Okay. So is this an old photo? Because most of the buildings now gone.
I think the underlying layer that we use for the plan is quite old now. I don't know.
Yes.
Any way to tell us, probably more than a couple of years old.
Okay. So the old hospital site itself is quite a big piece of land.
I think it's, yeah, I know Georgina, and there's about a couple of hectares. I think it's 3 point. It's off the top of my head, it's about 3.8 hectares.
Yes, so it's got those higher parts, it's got a gully running through too. Yes.
If you do get a chance to visit here, and I'm mindful that Lindsay obviously have commenced works here this week, it actually is really beautiful. Even with all of the junk that's still there, the gully is really beautiful. So the stream that runs through the gully area is known. We've seen it on old maps. It's I'm not 100% sure if it's Waipo number or Papapo number, but it would have. It's essentially that's the only remaining part of that stream that would have connected to the Mama Otuku.
It's not quite tall. Yeah. So the zoning of this is residential.
And under the proposed district plan, it's got a split zone in general residential and medium residential. Te Kotaitanga have submission points to that as well.
Right. Okay. So again, look, this is context, and we'll hear from the staff as well. Is a nurse's home, is that a loved building locally? The people sort of
there are some that are
say
connected to it because they lived there. They were nurses in Barrett Street Hospital. Their mothers were nurses at Barrett Street Hospital, and they lived there. And so, you know, there's definitely an affiliation to it, and
history with it.
And a history with it.
Big part of New Plymouth.
And it was a big part of New Plymouth. But I guess the flip side of that is that for some of us, we don't have that same affiliation to it, and for some of us we have the opposite reaction to it, which is, you know, many of our people died there through the influenza epidemic and the like, and you know, it's not all happy memories of that site for every section of our community. There are those that have an affinity to it, and there are those that don't.
Okay.
I don't know how widespread that is.
No, it was just want to get a sense for from Hawke's Bay, and pretty much everyone really recognises and sort of loves the Art Deco 1930s, the symbolism of recreation after 1931. And so just trying to get a sense. Yes. So what I wrote down in your paragraphs 23 and 24 when I read your evidence, there was Would you ultimately like the scheduling lifted? Question mark.
Yes.
Same with Pukekura, the old education board building, was that different?
We would love it lifted, but you know, where that particular building is in the very corner of the building. It's not at the main entrance.
Yes, it's a different.
We probably could work around it.
Yes.
But still we're stuck with exactly the same problem as the nurses' home, which is we have to recognise a site that we have no affinity to, but we now own.
Yes, but as also, as we all know, there's a requirement, the council has to list these heritage buildings that qualify to their criteria.
I think of the two, Otu Maikuku is more significant.
Yes.
And so we absolutely would want the scheduling lifted for that.
Ultimately, that would be.
That would.
Yes.
That would be.
So to be honest, ultimately that's residentially zoned, it's a key part of the site. It's going to have more potential for you with that building not there. And then you could well be thinking about taking through a consent to.
We'd like an easy path.
All right, look, I think it's helpful. By the way, I hated that education board office. As a 5-year-old, my father used to go and visit the education board every Friday night, leave us in the car for about